Chief Justice Emeritus, the main conveners of this symposium, the Rector ALPD, ED, IPs, the heads of institutions that are in the justice chain that are represented here. I've seen the prosecution, Rwanda Investigation Bureau, the Ministry of Justice, the Ombudsman, the Human Rights Commission, the Bar Association. The judiciary, of course, is part of the conveners. We have justices from the Court of Appeal, justices from the Military High Court. We have judges from the Intermediate Court and the Primary Court. We have also the prosecutors that are here from the Deputy Prosecutor General. We have the Prosecutor General of the Military Court, and the rest that are in this symposium that are ably come here. We also have heads of this civil society that are representing here, but also have representatives of the development partners from EU, from UNDP, the embassies that are also represented here. We have members of the academia that are well ably represented here. And definitely we have a resource person that's flew in all the way from Kampala, Uganda. Our guest keynote that will definitely have a moment to introduce when his time comes. Distinguished participants, ladies and gentlemen, a very good morning and warm welcome to every one of you. Of course, we have the Rwanda National Police that are also well represented today in here. So feel very welcome, welcome and welcome. And we're going to commence. We're a little bit, let's say 10 minutes late from schedule of time, but definitely we'll have a moment to redeem our time. To those that don't know me, my name's Harrison Mutabazi. I'm a judge of the High Court. I currently work with the Inspectorate Department. I'm also the spokesperson of the judiciary. I am also the point person for the benefit of this symposium. I'm also the point person for ADR steering committee in the judiciary. And I'm so very happy that I'm the moderate MC, the host in today's symposium, where we're going to be talking about plea bargaining and victim and offender mediation. This is the first ever symposium in our justice system where we've had both of these being deliberated upon with a very distinguished panel that you'll be seeing here, but also with a very, 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 very resourceful person that has been in this business for quite a very good time. That is our keynote speaker in this. So, ladies and gentlemen, please sit back and relax and enjoy, and definitely have a take-home from this that we're going to be having this way. So on behalf of the organizers, it is my great honor and pleasure to welcome you all to this high-level symposium on alternative dispute resolution under the theme, Plea Bargaining and Victim Offender Mediation, Building Capacity for Efficient, Restorative, and People-Centered Criminal Justice System in Rwanda. Today's symposium brings together key stakeholders, as I've mentioned, to reflect on the growing role of restorative justice in strengthening access to justice, promoting reconciliation, reducing case backlogs, and building a more humane and responsive criminal justice system. It also provides an important platform for sharing experiences, best practices, and innovative approaches towards effective implementation of plea bargaining and victim offender mediation in Rwanda and beyond. And as I want to tell those probably that are known from our circles, this all hinges from the policies that were adopted in 2022, the criminal justice policy and the ADR policies that were. So that is where we feature all these principles that we are now going to be deliberating on that are definitely functional, especially in the judiciary, in the prosecution, and elsewhere in that sense. My role is also to take you through on how the program is going to be running from now until the end. Shortly, we'll be having introductory remarks. First, we'll have an address from Professor Dr. Elvis Mbembe, one of the main conveners of this symposium. We're definitely thankful that they took time to definitely aid that this symposium come to happen. After him, he will have remarks from Director of ILPD, and then after that, we will have the keynote presentation from definitely our guest speaker who is in here, Professor Justice Andrew Hauha, who will be speaking us in that way. And then after that, we'll break off for a health break, and then we'll come in delving into the panels that are ably set here at that time. That is how we're going to be running. We'll have the group photo at the tail end. We expect to have our guest of honor who will be concluding the symposium, joining us at the tail end of our program. So we'll reserve time for our group photo at that time momentarily. So ladies and gentlemen, as I said, we're a little bit ahead of, we've lost a little bit of our time, so we want to not waste a lot of time at this juncture. Allow me welcome Professor Dr. Elvis Mbembe to come and deliver his remarks. With a round of applause, thank you so much.
Honorable Chief Justice Emeritus, distinguished representatives of the judiciary, the Rector of ILPD, representatives of the Ministry of Justice and other public institutions as enumerated by the moderator, esteemed judges, prosecutors, investigators, lawyers, scholars, development partners, distinguished guests, ladies and gentlemen, good morning. It is both an honor and a privilege for me to address you today on behalf of Initiative for Peace and Human Rights, IPEACE. Today's symposium comes at an important moment in the evolution of Rwanda's justice system. As our country continues its journey toward a more efficient, people-centered, and a restorative justice system, discussions around plea bargaining and victim offender mediation are no longer purely academic or theoretical. They are becoming part of the daily reality of justice delivery in Rwanda. At IPEACE, we are proud to contribute to this transformation. IPEACE is a Rwanda-registered non-governmental organization working to promote sustainable peace through human rights, good governance, and access to justice. For more than 2 decades, youth, detainees, and rural populations facing barriers in accessing justice. But beyond statistics, legal aid is about human lives. Last year, IPEACE had the opportunity to support a young woman whom I will call Diana. Diana was a 19-year-old university student in the first year of studies. She was prosecuted in Huye for abortion-related charges and faced prospect for a long prison sentence, a sentence that could have permanently disrupted her education, her future, and her life. Through legal assistance provided by IPEACE, plea bargaining was explored and successfully applied. This became one of our very first plea bargaining experiences directly handled by our organization. Today, Diana is expecting to graduate from university this year. Without that opportunity, she would be likely behind bars. The story of Diana reminds us that criminal justice reform is not only about reducing backlog statistics or improving procedural efficiency. It is also about preserving human dignity, proportionality, rehabilitation, and second chances. This is precisely why discussions around plea bargaining and victim offender mediation matter. From a civil society perspective, these mechanisms carry several important benefits for citizens. They can reduce unnecessary delays in criminal proceedings, limit excessive pretrial detention, reduce prison overcrowding, encourage accountability and reconciliation, give victims a more active voice in the justice processes, and promote restorative rather than a purely punitive outcome. For vulnerable citizens especially, timely justice can mean the difference between social reintegration and permanent marginalization. However, as we embrace these mechanisms, we must also proceed with caution and responsibility. Allow me to share a short parable. One morning, a hare was running frantically through the hills, and a goat stopped him, asking, this is the parable illustrated. The goat asked, "Hare, why are you running?" The hare replied, "I heard the authorities are arresting buffaloes." The goat laughed and said, "But you are not a buffalo, you are a hare." The hare answered, "Yes, I know, but as I know our criminal justice system, once I'm arrested, how many years will it take me to prove that I'm not a buffalo?" After hearing this, the goat also started running. This parable reminds us that efficiency should never come at the expense of justice. As plea bargaining and mediation mechanisms expand, we must ensure they are not transformed into shortcuts that pressure innocent or vulnerable people into admitting guilt simply to escape fear, prolonged detention, uncertainty, or systemic imbalance. Safeguards, legal representation, informed consent, judicial oversight, and ethical implementation will therefore remain essential. Ladies and gentlemen, last year, IPEACE organized a workshop together with the Ministry of Justice to discuss Rwanda's criminal justice policy and the practical challenges surrounding implementation of alternative mechanisms within criminal justice. Today's symposium and the series of trainings that will follow from May to June this year in partnership with ILPD represent a natural continuation of this collaboration between civil society organizations and justice sector institutions. This collaboration demonstrates something.
Director IPEACE for the elaborate remarks and for the food for thought that is brought up in this presentation as remarks on what the system is not ought to be, probably. Definitely our systems here, represented here, are not like that. It doesn't take a lot to prove that you are not a buffalo, definitely. So thank you very much in that sense. As I said, we'll also have remarks from Director ILPD, who's also definitely the core convener of this symposium. Director Dr. and Justice Eme Kalimunda definitely doesn't need introduction. We all know him, but definitely he's very much been a pillar in this. So as he comes, please put your hands together as you welcome Eme. He's one of the troopers that have been very ardent in supporting plea bargaining and that most victim and offender. So you're welcome for your remarks. Thank you.
Thank you, Justice Harrison, the moderator of this session. Honorable Chief Justice Emeritus, Honorable Prosecutor General, Deputy Prosecutor General, the Military Auditor General, Justice Professor Andrew Kauka, the Executive Director for the Uganda Judicial Training Institute, all the leaders represented here, including the Executive Director. We normally call him President and the CEO of Initiative for Peace and the Human Rights, the Country Director for Alert International, dear colleagues, friends, and all protocol observers, good morning. You are welcome to this high-level symposium on ADR in criminal matters, especially for plea bargaining and victim offender mediation. Victim offender mediation is the latest newborn in the family of ADR in Rwanda. Probably we'll be having other initiatives coming after victim offender mediation. We still have work to do around negotiation and adjudication. But by now in criminal matters, we're speaking about victim offender mediation in addition to the plea bargaining. The figures in plea bargaining are very promising today. I don't know if Justice Harrison has mentioned it or whether they will be mentioning it. But this process, the first year concluded by June 2023, where we had only 934 cases, lesser than 1,000 cases in June 2033. So starting from 2022 to 2023, we had 934 cases that had been resolved through plea bargaining. But by June 2024, the figure had rose to 9,851. So multiplied by 10, which is a very big achievement in 1 year. And by June 2025, the figures were 11,846. And there was another increase of more than 2,000 cases, which were resolved through plea bargaining. In May 2026, as we are speaking now, the figures from the judiciary indicates that we have 12,123 cases. So since June 2023, by today, we have 34,754 cases resolved through plea bargaining. So the figures by themselves are not meaningless, because this means people whose cases will be burdening the case backlog within all the institutions, the NPPA, the judiciary, the RCS, the Rwanda Investigation Bureau, and so on. So, and when we make a simple calculation, we found that since this process started, we have an average of nearly 10,000 cases that are resolved through plea bargaining per year. For the victim offender mediation, which is Rwandans before the law, as well as equality between men and women, the Constitution does not define by itself what it understands by the rule of law. But it makes, however, it makes the rule of law a precondition to peace, to security, and to national unity. We all know that life without law is insecure, and it is prone to dispute. So maintaining peace requires law and unbiased law, enforcers, and judges. Rule of law simply means that a person's treatment at the hands of the state or state agencies should serve a defensible common good. In other words, it is not enough to have laws and policies and to accurately apply them on particular persons. Laws and the policies, although established through democratic procedures, they must conform to certain standards of justice, something that transforms the rule of law into the rule of reason. Justice actors are always accountable to the common good. And the constant question should be, is the way I'm handling this case consistent with the rule of law? Or am I introducing a rule by law? Law enforcers should always remember that peace and justice are mutually reinforcing virtues, suggesting that the pursuit of one serves to augment the other. By including a Bill of Rights in the Constitution, Rwanda introduced the system of liberal constitutionalism. Although the Constitution does not define what it means by the rule of law, the Principle 6 of the preamble of the Constitution of 2003, the first Constitution, gives what should be the component of the rule of law: respect for fundamental human rights, pluralistic democracy, equitable power, tolerance, and my favorite is the resolution of issues through dialogue. This means that dialogue in conflict resolution serves the purpose of building a state governed by the rule of law. This was further emphasized in Article 9 of that same Constitution that reads as follows. I quote, "The state of Rwanda commits itself to conform to the following fundamental principles and promote and enforce the respect thereof." And the Principle 6 is the constant quest for solutions through dialogue and consensus. Later, the principle was reproduced expressis verbis in the preamble and Article 10.6 of the Constitution Amendment of 2015, and in Article 10.f and Article 11 of the Constitution Amendment of 2023. The amendment brought an innovation in Article 11 that introduced homegrown solutions as to deal with contemporary issues in the process of building the nation, promoting national culture, and restoring dignity. The Constitution encourages Rwandans and the Rwandan institutions to rely on the values in addressing modern concerns. Now, the question is, can we consider if, is it true if we should consider a crime to be a conflict? Is a crime a conflict? So the criminal, of course, is in a conflict with the law, and very often with the law and the victim. Since the Constitution is not exclusive about crimes, dialogue should also apply to them. It is common knowledge that a criminal investigation, prosecution, trial, conviction, and the sentencing are pursuing a common goal, as I said before. So the question is to know whether dialogue is a competent tool to achieve this goal. John Stuart Mill argues that the only freedom which deserves the name is that of pursuing our own good in our own way, so long as we do not attempt to deprive others of theirs or impede their effort to obtain it. So criminals deprive others of their rights or impede their efforts to obtain their rights. Criminals don't know or don't even care about the rule of law. So many civil law lawyers have mastered this famous principle that is constantly reproduced in Article 4 of the Family Code 2016. On ne peut déroger par des conventions particulières aux lois qui protègent les droits de la personne ou qui intéressent l'ordre public et les bonnes mœurs. This has led many justice actors to consider that a dialogue in criminal cases is not only illegal, it is also immoral. Michel Franchimont, the Belgian academic, very much favored by the prosecutors and often judges, says that la transaction, qu'on le veuille ou non, contredit les principes selon lesquels le ministère public ne peut pas transiger. In many civil law countries, criminal investigation is conducted by a unit of a gendarmerie. That is another wing of security forces. Gendarmes are not law enforcers as such, but a part of the defense corps in charge of protecting national security. In Rwanda, the reform that suppressed the Gendarmerie Nationale was introduced in 2000 by the law establishing the Rwanda National Police, which merged Gendarmerie Nationale, Police Communale, Inspecteur de la Police Judiciaire, all together in the Rwanda National Police. The three units, they belonged to different ministries, namely the Ministry of Defense for the Gendarmerie Nationale, the Ministry of Local Government for the Police Communale, the Ministry of Justice for the Inspecteur de Police Judiciaire. Civil prosecutors who supervised investigators had also the tendency to act as if they were part of the defense forces. Although it is the duty of all citizens to build a state governed by the rule of law, enforcing standards of the rule of law seems to be more the duty of law enforcers than it is for the defense forces. So plea bargaining is an English expression with the Rwandan value of dialogue. There is a Nigerian professor, academic who is called Afolayan, who developed a theory on African socioeconomic underdevelopment. And he says that, I quote, "It is false thinking for Africans to believe that they can find answers to their problems without understanding their own previous endeavors and experience at a time when it has virtually become an axiom that the past cannot be divorced from the present." So African law was restorative by nature. The argument basing the inexistence of a criminal law on harmful nature of the punishment, which we value, we think that the punishment becomes meaningful when it is harmful. Modern authors, such as the South African professor Snyman, have contradicted this theory by saying that a crime is a conduct which is legally forbidden and which may in principle be prosecuted by the state and which always results in the imposition of a punishment. The definition does not mention that a crime is a crime because the offender has to serve a term of imprisonment or has to be hanged. The practice of a suspended sentence, the practice of symbolic fines, the practice of a day fine regime that converts the amount of money into a period of imprisonment for poor offenders demonstrate that crimes are so because they are prohibited and punished by law. The fact of being so retributive has led African lawyers to underestimate the power of tools of restorative justice within their own traditional legal systems. When a plea bargaining, which was called a guilty plea or confession, was introduced in Rwanda in 1996, it was misunderstood. The process was almost a failure. And Stella Balbola, a researcher from Johns Hopkins University, made a research on the way plea bargaining was perceived by Rwandans in 2001, and they found the following, which we should avoid through this process that we're implementing today. The researcher found that knowledge about the benefits of a confession and a guilty plea was very limited. 20% admitted not to know its benefit. 10% said it presented no advantage at all. And 23% had lied in order to get an acquittal. So if you combine these percentages, by then, we'll find that nearly 60% in 2001 were disagreeing completely with the plea bargaining. However, we know that in jurisdictions that effectively apply plea bargaining procedure, such as the US, it absorbs 90% of a felony suspect. In the UK, only 60% of prosecutions in the magistrate court go to trial, and the 7% in the Crown Court go to trial. In countries that apply diversion mechanism in criminal justice, it is generally accepted that before submitting a criminal case to the court, the prosecution must assess whether the file satisfies these three standards. I don't know whether in our prosecution, the prosecutors, they verify whether a file before being submitted satisfies these three standards. The first one is whether there are sufficient evidences. The second one is whether there is a realistic prospect of a conviction. The third one is whether it is in the public interest to submit the file to the court. So the objective is to have a better quality preparation that would allow a faster process with fewer cases discontinued or dismissed by the trial judge. So it follows that only serious crimes should be prosecuted, whereas less serious crimes should be systematically diverted. So it is in this regard that in partnership with the Institute, the Initiative for Peace and Human Rights, and together with Alert International, and there is another organization which you don't mention often, Paul Institute, the justice sector has started from this Monday empowering justice actors. We are planning that by 31st July, we should have trained 420 justice actors, advocates, judges, prosecutors, and investigators in these procedures of plea bargaining. And all the trainings, they start by understanding 2 days mandatory training on the justice values in the Rwandan culture. So we bring people who are not lawyers to teach the justice actors about two amazing things. I don't know whether Mr. Bardok is in the room, yes. But there are two amazing principles, inzira ya ruhinyuza n'inzira ya rushyamo. Inzira ya ruhinyuza n'inzira ya rushyamo niho ubutabera nyarwanda bwari bwubakiye. Ku buryo iyo umuntu amaze kumenya inzira ya ruhinyuza n'inzira ya rushyamo, ibi byose tuvuga mu mategeko yacu bihita byoroha, uhita ubyumva mu buryo bworoshye kubera ko niwo musingi w'ubutabera nyarwanda. Ubwo rero kumva inzira ya ruhinyuza bituma twibaza buri gihe ingaruka z'icyemezo tugiye gufata mu rwego rw'ubutabera. So, Honorable Chief Justice, Honorable Prosecutor, Deputy Prosecutor General, distinguished guests, all our distinguished panelists, we really thank you. This symposium is organized under the patronage of Honorable Chief Justice. She would have liked to be here, but today's symposium collided with another high-level event organized by Unity Club. And therefore, many of the leaders who should have been here, including the Honorable Chief Justice herself, could not make it this morning, but we expect others maybe to be joining us later. So we thank you very much, and IPEACE, Alert International, the Judiciary, ILPD, and the Polling Institute, we value your support. We don't take it for granted. And we believe that this high-level symposium will be an opportunity for the leaders to understand this ADR mechanism, especially in criminal matters. Thank you very much.
Thank you very much, Dr. Aime, for that profound remarks that are very profound, that have taken us through what plea bargaining is in that sense. And definitely, you said we didn't talk about statistics. I didn't say mention about statistics, but definitely I know after our break, we will have a very high-powered panel that is going to be taking us through the statistics that we have in the prosecution, in the judiciary, in the Rwanda Bureau, Rwanda Investigation Bureau, and the rest. So I skip this intentionally for that. But thank you very much, Dr. Aime, and definitely Dr. Mbembe, for your opening remarks that are set base and base for this symposium in this way. Now, as I told you, we have our keynote speaker who is going to give us a presentation. He's not very much an alien to us here in Rwanda. Actually, I would say he's been very much pivotal in introducing us to plea bargaining. I first saw him here in Rwanda in 2014. Isn't it, Justice? 2014, when he came here when Chief Justice Emeritus was still Chief Justice, and they came together with the PG of Uganda, Justice Yorakum Bamwine, I think, yes, to come and tell us about plea bargaining. Well, that was very strange to us. I was in a room and the rest of our colleagues that were in, and when they said plea bargaining, we said, what in the world? How can you bring plea bargaining in a system and this way? And we said it couldn't happen. But lo and behold, some years after this, now this we're talking about plea bargaining and happening. So I would say the mustard seed that you saw we've seen it grow into a very big tree that is coming here. As they said, it's only barely 40 months that we rolled out plea bargaining in the courts and everywhere, but we are proudly saying we have over 30-something cases that are being achieved. We've only rolled up in 8 months victim and offender mediation. We have gone over 1,000 and so cases that have been resolved through victim and offender. And actually, what the doctors said and the rest have said of restorative justice, we are seeing it vividly happen in these processes. We've seen victims and offender reunite, and actually victims saying, I forgive you, I even don't want anything from you. And that is the principle that we are raiding on as the country like Rwanda. So it's my distinguished honor and singular to introduce my brother and friend. I'll read the bio for him to be known well to you. Honorable Justice Professor Andrew Hauha is the Executive Director of the Judicial Training Institute of Uganda and a High Court Judge in charge of professional judges training in the judiciary of Uganda. He also serves as the focal judge in charge of alternative dispute resolution in the judiciary of Uganda, where he's responsible for coordinating the implementation and rollout of ADR initiatives across the judiciary. Justice Hauha is the judge of the High Court of Uganda at the Criminal Division and plays a vital role in promoting efficiency and access to justice. He further serves as the judge in charge of the day-to-day activities of the Africa Chief Justice ADR Forum, which Rwanda is also part of, connecting efforts with the judiciaries across Africa to advance the adoption and institutionalization of ADR mechanisms on the continent. In addition to his judicial duties, he's also the adjunct professor at the Caruso School of Law, Pepperdine University, where he contributes to advancing global understanding and scholarship in dispute resolution and judicial practice. Honorable Justice Professor Andrew Hauha was installed as the 4th Chancellor of Livingstone International University. Previously, he served as the technical advisor to the Chief Justice and the judiciary top management on reforms within the judiciary. He was appointed on secondment from the Uganda Law Reform Commission at the request of the former Chief Justice, Honorable Justice Benjamin Odoki. His appointment reflected over 2 decades of expertise in judicial reform and legislative development. In this role, he guided senior judges through transformative reforms and played a central role in drafting critical legal instruments, including the civil procedure rules, land eviction guidelines, and plea bargaining framework. His initiatives significantly reduced case backlogs, strengthening area mechanisms, and modernizing judicial process across Uganda justice system. He was the lead researcher behind the development of Uganda sentencing guidelines and the roll out of plea bargaining notably. He led the research and drafting of the first ever sentencing guidelines in Africa, a landmark reform that introduced consistency, fairness, predictability in sentencing, reducing disparities and reinforcing adherence to the rule of law. In addition, he spearheaded the proposal and framework for implementing plea bargaining within Uganda's criminal justice system. Ladies and gentlemen, please put your hands together as we welcome our keynote speaker. Thank you very much.
Thank you, my Brother Harrison Mutabazi, my Lord, the Honorable the Chief Justice Emeritus, I bring greetings from your friends, His Lordship, the Chief Justice Bart Katrebe, your former student, the retired Chief Justice Owinyi Dolo, and also the current Chief Justice. But in a special way, I want to congratulate you, my Lord, CJ Emeritus, as my brother Harrison indicated. Today reminds me that afternoon when we sat at your chambers having a conversation on how best Rwanda can adopt the plea bargaining processes. And where I say we need to congratulate you, God has been kind enough to give you life to witness plea bargaining taking shape. So we really congratulate you, and I would request that we put our hands together to clap for His Lordship. Participants, before I say what I'm going to say here, I just want to share with you three things or three experiences that I have had in handling plea bargaining cases. One is of a man who was called Salongo. I think I was told by my brother, the rector, yesterday that in Rwanda also a husband who has fathered two children that were born at the same time is also referred to as Salongo, and the mother of the children is referred to as Nalongo. So we had a man who believed the twins were his. Little did he know that the twins were for his best friend, who used to take him to the pub, buy for him alcohol, escort him to his home. As he would put him in the sitting room to sleep, he would go and have sexual intercourse with his wife. So twins were fathered. So he thought the twins were his, and he enjoyed the title of being referred to as a Salongo. So whenever they would go in the joint and he's posing how he's a Salongo, other people in the joint would undermine him. But they would never tell him who the father of the twins were, because it was his friend who was always seated next to him in the pub. So eventually when he came out, he bought a machete, went back home, found the lady breastfeeding the children, and chopped off their heads, and also cut off the hands of the wife as she was struggling to save the lives of these twins. Now his only son with this lady, who was also seeing what was happening, began making noise, and he ran after him and also cut off his head. This matter came for plea bargaining in 2014 when we were rolling out plea bargaining. The question we had in the room was whether this should be a matter for plea bargaining or not. The second scenario that I would share with you, this was a lady who was a witch doctor. If they stole anything of yours and you want it recovered, you would go and report to her. You need not to go to police, just go to her, and she would come to the place where the things had been stolen, and whoever has stolen those things would either bring them back there, or she would make certain proclamations and certain evil things will be visited on those people. So when the cows were stolen, she came and the entire village was called, and she said anybody who stole these cows should bring them. And if the cows are not brought, within the next 2 days, the people who stole the cows will come here and they will be found dead. And indeed it happened. 2 people came back and they were found dead. So the relatives of these two people visited mob justice to the shrine of this lady, and they really caused havoc in the community where this lady was. Police came in, the lady was arrested, and she was very consistent that I am responsible for the death of those two thieves. So she was kept in prison, and the prison warders were so afraid of her, to the extent that whenever they would disturb her, she would say, I would speak to these gates and they would open. They had to transfer her and brought her to a much more high-end security facility. She wanted to plead again. We asked ourselves, was there evidence that she caused the death? Certainly there was not, because the postmortem report did not indicate that the cause of death was witchcraft. This goes to the things we need to pay attention to here. If we are going to implement plea bargaining, is plea bargaining for every case? If we are going to implement plea bargaining, can we take on to accept people to bargain where there is no evidence against them? We all know that if you are to prove death, the ingredients are clear. That the person died, and you prove death by either people who saw, you prove death medically by a postmortem report. You also associate the cause of death to the accused person. Once any of those are missing, including the fundamental malice aforethought, then it becomes very difficult to prove a charge of murder. So if you have not been able to prove any of those, or one of those, and I say I killed, can I be part of the plea bargaining program? Those are very pertinent questions that we need to answer. The last example that I would want to share is, this lady was married to her husband. At the age of 14, the husband was 16. These were young village adolescents in a place called Masaka. They lived together for 20 years, and they became very wealthy. And these were semi-literate. But you can imagine, God bless them, they were coffee exporters, very rich. I don't know what happened to the lady, but she mobilized the robbers to come and rob them. She said, I'll leave the door of the house open. When you come, pick the money, but don't kill my husband or beat him. And one of the people that was involved was her biological brother, who I think she brought because she trusted him that when they picked the money, the brother would keep it well and eventually pass it to her. Unfortunately, they did not manage it well. The husband was able to recognize his brother-in-law as a part of the thieves that were robbing. I say, hey, my muko, even you. And that caused the man to die, because the brother-in-law realized that if he's not killed, he will be able to say that he saw him. So the man was killed. Eventually, investigation is commenced, and the lady expressed interest in a plea bargain. This file was brought before me. Is it a matter for plea bargaining? Now, the reason I am posing these questions is to tie the theme that we are talking about here. The theme is victim-centered, victim-centered. And this takes me to the question of this whole thing we call justice. When we talk about justice, what do we mean? Whose justice is it? Is it justice for the judge? Is it justice for the police officer? Is it justice for the defense lawyer? Is it justice for the deceased or the person affected by the offense? Whose justice is it? Is it justice for the public? Because quite often we talk about public policy. So whose justice is it in all these cases that I have talked about? I'll go into telling you how I handled some of these cases. I was not the judge in the case of Salongo, but I was so involved in Salongo's case. And I remember telling the judges that Salongo is eligible for plea bargaining. And they said, no, he cannot. I said, in my view, what matters is the sentence. What matters are the procedures and processes that we have to take Salongo through. That is what matters. Fortunately enough, they agreed with me, and I told them that what matters is let's hear from Salongo what sentence he is willing to take by himself. Because if you are going to do a plea bargaining, two people can initiate it. It can either be the accused expressing interest in it, or it can be the prosecutor. So since Salongo is willing to take a plea bargaining, let's hear from him what he is interested in taking. And Salongo said, I am willing to sign for death. We were not very sure whether Salongo was sane, because nobody can be interested in saying, I am willing to sign for the death sentence. So we engaged Salongo and asked him, but why? He said, I have no reason to live, because I don't have a family. I feel like I really betrayed my family. I betrayed myself. I feel I am a useless person. What was interesting, we asked Salongo whether he would be interested in meeting his wife Nalongo, who is still living up to date but with no hands. And he said, Nalongo visits me 2 times every month. She comes to the prison to visit Salongo. And he comes with Salongo's relatives bringing food for Salongo. So we asked her what conversation they always have, and he said she has since forgiven me. We looked for the relatives of Salongo, we looked for the relatives of Nalongo and Nalongo herself, and she reiterated what Salongo told us. We asked her what sentence she would be interested in seeing Salongo to serve. She said, I have forgiven Salongo. I cannot talk about any sentence. The rest is for the government of Uganda to decide. But Salongo's interest was death. So that helped us to eventually work with the prosecutor, and Salongo plea bargained for natural life in prison. But what processes did we involve? We did not hurry the bargain. We did a community impact statement. We put it on the file. We got the views of the community about the offense. We got the views of Nalongo, how the offense had impacted her, psychologically, emotionally, financially. All that was done. It was put on the file. Salongo was subjected to medical examination for us to be sure, because the kind of sentence Salongo was going to get was quite hefty. So wanted to be sure. The processes that we took Salongo through, to be sure he understands the sentence he's signing for, to get his reasons why. So for us in Uganda, we plea bargain in a case. What is different is the sentence. What is different is the processes that we take through. The case flow processes are a bit detailed when you are handling plea bargains that are high-end. High-end in the context of the offense is really heavy. I'm sure some of you may have read through the media and seen about 4 or 5 years ago, we had a case of Uganda versus Kanyamunyu. Kanyamunyu was driving his car on the streets of Kampala, and the one Akena scratched his car. He was also driving. feeling provoked by the scratch, Mr. Kanyamunyu picked a pistol and shot at Akena after a fracas ensued. I think he felt sorry for what had happened. He carried Akena and took him to the hospital. Unfortunately, Akena lost the battle. He died. But he said, the person who brought me here in this hospital is the one who shot at me. Was that a matter for plea bargaining? Yes, it was plea bargained. How? We looked at the African norms and traditions of the Acholi people, where Akena came from. And the humble person who was really very remorseful about the death subjected himself to the traditional Acholi cultures, what is normally referred to as matoput. It is a set of rituals that you have to go through if you have caused somebody death. And their justice system deals with you, but that does not mean you don't come back to the formal justice system. So when he came back to the formal justice system, he presented all that he had done in the Acholi culture. The bargain was for 5 years. Period spent on remand was subtracted because it is a constitutional duty. He served his sentence. He's out of prison. But what is very critical here, the kind of responsibilities that Kanyamunyu took over from arising out of that discussion included the following. One, taking responsibility of the obligations that the late Akena used to do. He took over the responsibilities of even playing a central role in the education of the people that Akena used to support. I'm told at the deathbed of the mother of Akena, she said, I have died a happy woman because my son received justice. Would the situation would have been the same, assuming Kanyamunyu was tried, sentenced to death, sentenced to 50 years, would that have been justice? Maybe it would have been justice for the judge. Maybe it would have been justice for the prosecutor to go and tick on the number of convictions he has been able to get. Would it have been justice for Kanyamunyu? I don't think so. So the theme that we are looking at today, mathematically, it is 360-degree justice. It is not 180, it is not 95, it is not a 45-degree. It is 360-degree. Now, what we have emphasized back home is we need to distinguish ourselves from the job that we are supposed to do and the personalities that we hold. As judges, as prosecutors, as defense lawyers, do the jobs that you are supposed to do, but don't become the job. Quite often, we become the job. We tend to take up these cases, become so emotional about them, more than those that have been affected by the crime. I was telling the team yesterday in Nyanza that in our culture there is a saying that if you have your neighbor and your neighbor loses a child and you go and mourn more than the neighbor, there is a high likelihood that you are the cause of the death. Now, whatever that means, I need to find out. But the point I'm trying to make here is, why can't we promote reconciliation among people? You find a prosecutor saying, I have my evidence. But the victim is saying, listen to me. We have made peace. I'll now take you to Karamoja, from Acholi to Karamoja. In Karamoja, when you cause death of a man, within the Karamoja justice system, you pay 60 cows. When you cause death of a woman, you pay 120. So in Karamoja, it is cheaper to kill a man than to kill a woman. Now, if you kill any of those, and you subject yourself to the Englishman's court, this is where Justice Harrison sits, and he convicts this Karamajong to 20, 30, 40, 50 years, even death. The crime will cease to be personal to holder. It will become community. It will breed hatred among the family of the accused who is serving a death sentence because he can't go back, and the family that lost their person. So the kind of crime that has been committed has become now a kind of a communal thing. Assuming you serve a custodial sentence and go back home, I'm telling you the following day in the morning, the cultural leaders will come, the elders, and they will tell you, come to the court tomorrow. You will not tell them that I served my sentence in Luzira. A man in Karamoja caused the murder of his relative. He was sentenced to 25 years in Luzira prison. He served the sentence, he came back. The following morning, they went to him, they said, please come and answer. He said, I finished. They killed him. So whose justice was that? Was it justice that they had gone to the courts? Was it justice that was this side? What point am I making here? Just like many African countries were affected by the scramble and partition of Africa of 1884. And when these fellows came to our countries, they introduced their English system, as my brother, the Honorable Justice Moyoboki said. And they introduced alien pieces of legislation to us. We have case backlog because of that. My Lord C.J. Emeritus, you will perhaps help us understand whether there was case backlog in the traditional African society. I don't think there was case backlog in the traditional African society. In Uganda, we undertook a study with an institute called HIL. And the study revealed that 10% of the disputes that occur in the communities are the ones that go to the courts. 90% are resolved in the communities. I don't know whether such a study has been conducted here, but I do not think the situation could be different. As we speak now, people in the communities are resolving disputes. It is those that they fail to resolve that come to the court. What is unfortunate, the 10% in Uganda that comes to the court takes us many years to resolve. And I want to thank the head of IPIS for the illustration he showed of hare, the goat, and the buffalo. Honestly speaking, how long will it take for the court to determine that this person is not a buffalo, the person is a hare? But you would have spent 6, 7 years on remand. Now, I spearheaded a study with the support of the Commissioner General of Prisons of Uganda, and this is what we established. The prison population in Uganda at the time was 70,000. And out of that, more than 60% were remand prisoners. The rest were convicts. When we introduced plea bargaining, the narrative changed. We now have more convicts than remand prisoners. But what was so hurting was each day government of Uganda spends $9 on each of those people in custody. It would be no harm to spend money on those that have been convicted. But spending money on remand prisoners, who some of them tomorrow will be found to be not guilty, who some tomorrow will be found to be guilty, given long custodial sentences, which for us we think are justice. Government spends $9 on them, but the parties who are affected by the disputes, do not feel like they have gotten the justice that they demand. So for me, I want to state by saying that 1, we can plea bargain all the cases. 2, we need to begin small. Chew a small piece at a time. 3, police officers, National Prosecution Authority. These cases are not your cases. Where they were committed, you were not there. You were called to investigate the case because you're exercising your constitutional duty. As you exercise your constitutional duty, bear in mind the holistic spirit of the Constitution of Rwanda, as stated by my brother Justice Aime. The provisions of Rwanda, he talked about Article 10, he talked about the preamble provisions of the Constitution of Rwanda. They are all preaching one thing, peace. They are all preaching one thing, reconciliation. And the Constitution of Uganda is coiled in the same spirit. This is what it says, that when courts are adjudicating civil and criminal matters, they will promote reconciliation among parties. So I do not think that promoting reconciliation is illegal. I do not think that promoting reconciliation should have boundaries. I think what promoting reconciliation should have is nothing but a bit of detail depending on nature of the offense. If it is a murder, can we give it a bit of time as we plea bargain it? Can we bring all the parties that are affected by this murder in as far as the exercise of the discretion of the national prosecutor thinks? Let's have all these people on record. Let's prepare a detailed plea bargain record. Now, many people have not understood this. It is easier to conduct a trial than to do a plea bargaining. And the reason is simple. A trial, as a judge, you are seated hearing from the prosecution, hearing from the defense. You take a decision. Anybody that was not a party to the investigation, anybody that did not record a statement during the investigations, cannot come to be part of the trial without leave of court. And that is what makes plea bargaining complicated. It is complicated because you bring together people who you think you have to consult. You don't limit yourself to the file mentality. But with the plea bargaining, you resolve disputes. You resolve. And when you talk about resolution, you are talking about total closure of the dispute. The adversarial way of trying cases, you give a decision. And that's why we have to distinguish between a court decision and a resolution. In fact, courts are more inclined to giving court decisions, and court decisions are quite often appealable. I have never come across a resolution that is appealed against. I'm not saying that plea bargain may not be appealed against. It may be appealed against if the procedures have not been paid attention to the letter. So for me, I want to tell the participants here that 1, plea bargaining is not alien to the African justice system. As we all know, in African tradition, the only way of resolving disputes was dialogue. It was never a monologue at all. The whole idea of being one-sided is when we're visited by the colonial masters. So what we are doing now is the way to go. What we need to emphasize is to have a bit of detail, ensure that the processes are followed, ensure that the stakeholders are consulted, do a lot of sensitization of this program. We have been running plea bargaining in Uganda for the last 12 years. But up to today, we still have sensitization inefficiencies. Because people come, people go. People come, people go. What do I mean? The candidates for plea bargaining are people who are in conflict with the law. As we speak now, even in this room, there are people who are conflicting with the law. Police is arresting people out there. So when they come in, they have to be informed about plea bargaining. The victims of offense are also different. So plea bargaining sensitization is continuous. So it is very important for us to be able to pay attention to that. Now, look at the cost of a criminal trial. In Uganda, the cost of a criminal trial at the High Court is approximately $400 US. I'm using dollars because it will be easier to convert than talking about shillings. That's the cost of a criminal trial. What does this cost entail? Who are the ingredients within the cost? Capital offenses, the state is supposed to pay for you counsel. So out of the 400, there's a portion that goes to counsel, state counsel. Then there are logistical issues involved in terms of witnesses, expert witnesses, and all this, depending on the nature of the offense. So the cost is $400. Now, when it comes to a plea bargaining, the cost is $100. What that means is, what you spend on one case, you do 4 cases. But mind you, the $400 you have spent on this one case, it will go on appeal. You will spend more money there, up to the Supreme Court. But forgetting that there is one cost which is not easily quantifiable, and that is the cost of justice satisfaction needs of the people that have been affected by the offense. We are now simply talking about satisfaction by a judge who said, I concluded that case. So the judge will get the statistic. So as far as the justice needs of the presiding judge are concerned, they have been achieved. The prosecutor will go to the DPP, the head of the prosecution authority, and say, my boss, this one I have closed it. So that the box will be ticked. The accused is complaining about the kind of sentence they have been given, much as they may have committed the offense. The victims of crime or their representatives are also complaining. They are not perhaps satisfied with the decision. So when you talk about the cost of administration of justice in criminal justice, the cost where you can look at both quantitative and qualitative tests is plea bargaining. Everybody there gets what they are supposed to get. Let's try cases that we should try. Let's try matters that we should try. And from the time we began, we have saved 38 billion Uganda shillings. I don't know how much that is in terms of dollars, but since my brother Harrison has lived in Uganda before, he can compute for us the 38 billion in terms of how much that is in dollars. Now, the space of inmates in prisons. In Uganda, we had one prison facility which was built for 600 inmates, but it was housing 2,800. I don't know whether you can call that housing or storing. So when you look at, when we went into plea bargaining, the prison population in that facility substantially reduced. It is not that people were told to go home, no. Those that were convicted through plea bargaining were sent to the prison farms. Those that were able to get sentences that had been served well on remand went home. Some were given community service, but it depended on the kind of offenses. So the population substantially reduced. So it is important that we look at the benefits of plea bargaining from the perspectives of both qualitative and quantitative. As my brother Harrison said, in 2024, 22 judiciaries of Africa convened in Kampala. I think we had representation of about 12 chief justices, 16 chief justices, and Harrison represented the CJ of Rwanda. This conversation was discussed at a continental level. And the resolution the CJs of Africa said was, can we prioritize ADR as a mode of case disposal? And in fact, one of the CJs moved a motion that that ADR is not alternative dispute resolution. He said, I move a motion that ADR is Africa dispute resolution. So we are still in that debate. He went ahead and said, I move a motion that Africa dispute resolution is original dispute resolution, and that what the colonial masters brought to us is the alternative. So bring witnesses to testify in court and all this, that is the alternative. And that those CJs, that was CJ Zimbabwe, who recently retired, Luke Malaba, and CJ Uganda, who also recently retired, Justice Owinyi Doro. They moved that motion. Lastly, a year ago, we visited the president of Namibia under the auspices of the Africa CJ's ADR Forum. So when we were briefing her about the forum activities, she looked at the Chief Justice of Namibia, the Honorable Justice Peter Shivute, and she said, I am happy that we have had this conversation. And then she said, a few weeks ago, my goats were stolen from my farm. I did not go to police because I knew police would tell me record a statement. I knew police would tell me what were the colors of the goat, what time the goat was stolen, who was there. We need a statement from your farm manager. So he says, all I did, I went to our chief of the community where the farm is. I said, Chief, my goats were stolen. He said, okay. He summoned his agents, the agents of the chief were summoned by the chief. She said, I left, and by evening they had got the thief who had stolen my goats. Now, what system was used to get the thieves? It is the traditional African mode that was used. And what is interesting is, she said, I did not even follow up to have those people punished because I knew the system on the ground would have them punished. And indeed, they were punished by the system on the ground. And I don't think the system was sending them to prison. It must have been a much more meaningful sentence. And I want to tell you that I think if you are sentenced in the community where you have committed the offense, especially by the community leaders, there is a high likelihood of reform, because then everybody looks at you. So it is important that we promote this thing. It is a very good thing. It brings peace. It promotes total closure, healing. But lastly, as I move away from here, I think we need to understand the definition of what the law is. Many scholars have defined law differently, as we all know. There are those who are from the social anthropology school of law who have defined law as social anthropology. And I think for them, they say law is social anthropology because you legislate basing on the circumstances of the time. That is social anthropology. So what are our circumstances of this time? But that should also be guided by our history. And then you have the legal positivists, I think, who define law as what it is, as opposed to what it ought to be. And I think that was St. Thomas Aquinas, I think, if I'm to remember. Now, which school of thought do you want to adopt here? My view is, my humble view is, let's adopt the school of thought that speaks to the current circumstances that we live in, guided by the law as it is, but look at the grand norm, which is the Constitution. If the Constitution is saying promote reconciliation, restorative justice amongst parties, who are we to say that no, for me, I have to take this person through a full trial? Thank you very much for listening to me. I have the copy of the presentation. I was scanning through, just to ensure that we don't lose time. But the copy of the presentation is available. Thank you for listening to me. Thank you.
All right, I'd like to thank very much my brother, Justice Andrew Hauha, for the presentation that he has labored to take us through plea bargaining, but in a very simple manner that everyone else can understand very well, and very well touching on what matters can be plea bargained and the role of the community in this process in that sense. So definitely he's still around here with us, and you can reach out to him with any question, but definitely during plenary, I don't think he can answer some questions from the gallery at that time. We are transition to our break. We will have a short break due to time that we have, and I beg that we come back at around 11:55 if we can do that. Please don't lose us. Don't lose us. We have a very high-powered panels that are going to be taking us through after the short break, and please stay with us as we transition. So, as I said, we are supposed to have a group photo, but since our guest of honor isn't in the room yet, we'll have the group photo at the end of our sessions today. So please let us usher ourselves out for a break, and then we'll return here at around 11:55 for the panel presentation. Thank you so very much. Please, you're welcome. And the panelists are going to be moderated by her. We have Mr. Twagirayezu Jean-Marie, the Director General in charge of criminal investigation, RIB. Please give him a clap as he comes on the platform. And we have Justice Habarurema Jean-Pierre, President of the High Court. Please give him a hand as he comes on the platform. And then we have the Deputy Prosecutor General, Mr. Bonaventure Ruberwa. Please give him a round of applause. And lastly but not least, we have Counsel Focus Rutembesa also joining us. Please give him a round of applause. As you can see, the entire chain is well represented. And moderator, you have the platform. Thank you. Yes, sir. There's a mic. I can.
Honorable Chief Justice Emeritus, distinguished guests, invited dignitaries within this room. I wanted to say good morning, but I believe it must be now good afternoon. Yeah, so allow me welcome you to this panel discussion on plea bargaining, focusing on victim and offender mediation. I was already introduced. My name is Charity Wibabara, and I'm privileged, humbled, but also honored to be the moderator for this conversation on plea bargaining. And we are also fortunate to have high-profile officials with us on this panel. And they've already been introduced, but just to give them another welcome, besides me is Deje, that's the Director General from Rwanda Investigation Bureau, Jean-Marie Twagirayezu. Welcome, sir. And we are also honored to have the President of the High Court, Mr. Jean-Pierre Habarurema. Welcome, Justice. Yeah, and with us, we also have the Deputy Prosecutor General, Mr. Ruberwa Bonaventure. Feel welcome on this panel. And we have also, the last but not least, we have a representative from Rwanda Bar Association, Maitre Focus Rutembesa. Feel welcome. So the discussions are not going to be limited to us. We will have a time for question and answer, but also for comments. And I will not preempt the discussions. My role is just to moderate this session. When you look at the topic or the subject matter under discussion, the goal of this panel is going to focus just on sharing insights, because we are going to hear the different and unique perspectives of each of the officials here represented. But also we are going to have an engaging discussion and dialogue as we bring matters into discussion of concern regarding plea bargaining. So without taking much time, allow me start off with the questions. And I'll start with Jean-Marie to tell us more about this concept of plea bargaining within the Rwandan Investigation Bureau, where it commences. I don't want to say that you're the only ones at the forefront, but at least you're at the entry gate. Can you briefly take us through the process and if there are challenges that you encounter, specifically in accelerating plea bargaining? We would love to hear that. And if there are limitations also in accordance with the law, I think every one of us is interested in knowing that. So the microphone is yours. Welcome.
Thank you so much, moderator. Honorable Chief Justice Emeritus, members, all protocols observed. Good morning or good afternoon once again. It's my pleasure to be part of this discussion. Going straight forward to the question by the moderator that does RIBO do or pre-bargaining or initiate pre-bargaining as a concept, especially as a legal concept in a Rwandan context. We all know that pre-bargaining is a criminal procedure mainly driven by the prosecutors from our National Prosecution Authority. So it doesn't start at RIB of Rwanda Investigation Bureau. Though parties involved may express their willingness to cooperate and willing to negotiate some agreements at investigation level, probably our role would be to investigate, collect evidence, and even record some of the concessions or agreements and cooperation agreements, and probably inform the prosecution when we submit the case. And then the prosecution will be the one to initiate pre-bargaining process. But for RIB, at our level, we do only initiate mediation, victim-offender mediation. And in this process, we all know that it's a process that requires participation of both parties, victim and the suspect. And sometimes it can also be initiated by the investigator having seen parties' expression of interest in this kind of negotiated settlement. So back to the challenges. There are different challenges starting from legal, institutional, cultural, and practical. Starting from the legal challenge, we all know that we only initiate mediation in some cases because the law restricts mediation to minor offenses and exclude serious crimes like murder, sexual violence, and corruption. So expanding the scope of mediation, it would require legislative changes. Two, especially from legal perspective, as we all heard about it, even from the presentation by the previous presenter, that there is a need for due safeguards in this kind of process. So legal practitioners, for them to initiate mediation, they need also to obtain parties' willingness, informed consent, and verify that there is no cohesion, there is absence of cohesion. And this is time consuming because you need to engage involved parties. Another aspect is about the evidence, evidential requirement, because we only initiate mediation after doing investigations. You need to obtain evidence about what happened. If you are to engage parties, you need to engage parties when you all know about the truth of what happened. And sometimes those evidence will be the ones to inform pre-bargaining or concessions from different, from involved parties. So from institutional perspective, there is a need for skills, for capacity building. The staff involved, the legal practitioners involved need to be trained on how they can conduct these sessions. And sometimes we do not have specific units that and the staff that are special trained for doing this, and sometimes it doesn't facilitate the work involved. From cultural perspective, we all know that public perception, the existing public perception, it always refers this kind of mechanism, these settlement mechanisms, they are always referred as a deal for criminals. So victims tend to be reluctant to adopt such kind of mechanisms. Even the defendant, sometimes they may not be willing, fearing some repercussions, because if you are to concede, to accept for a negotiation outcome, there are some concessions even from the defendant side, and even including even the compensation. Sometimes it may not be easy for even for the other defendant party to respond. Even legal practitioners, they tend even to be reluctant, because conducting mediation is also time consuming, and for them they are litigation focused, and they are, in most of the time they will be evaluated based on the outcome of convictions, and they tend not to accept to make it a priority in their daily work. And even from practical perspective, there are some logistics involved, the staff involved, the time involved, but also even after getting some concessions during mediation process, if either one of the parties doesn't comply and facilitate the process to achieve what was expected, then it will reduce the chances to succeed even if in future cases. So though we are seeing the trend that Rwanda Investigation Bureau and the other institutions in the justice sector, they are increasingly using these kind of mechanisms, because if I can, and this can be maybe measured by the figures. When we consider the figures, when we started using this kind of mechanism after adopting the law in 2023, up to now, we can see that every year there is an increased trend of using this kind of mechanism. So we are still, we are saying that we are trying the best, but we are still at early stage, but there is need of a lot of things to do, especially trying to address those challenges. Thank you.
Thank you very much for sharing the insightful comments, the challenges that you're facing. Now going to the Deputy Prosecutor General, and it's also good that you highlighted the focus of Rwanda Investigation Bureau. Sometimes there's a confusion that RIB does plea bargaining. So, you know, all these alternative dispute resolution approaches are sometimes confused: plea bargaining, mediation, and others that are not a focus of discussion today. So I would love to hear from NPPA, how do you engage with RIB? Because plea bargaining is initiated at the prosecution level, but do you have any engagement or collaboration with RIB in that regard? But also I would love to know, or the audience here is interested in knowing, what is the contribution of NPPA in the social cohesion? Thank you.
Thank you, Moderator. Honorable Chief Justice Emeritus, dear participant, I would like to thank the organizers for inviting National Public Prosecution to participate in this high-level symposium. This discussion comes at an important moment in the continued evolution of Rwanda's criminal justice system.
across modern justice system, there is an increasing recognition that the criminal justice must achieve more than punishment alone. It must equally promote accountability, efficiency, restoration of harm, reconciliation, and public confidence in the rule of law. And we all know that in our country, this understanding carries particular significance. Coming back to the question, allow me to begin with how the National Public Prosecution Authority collaborate with the Rwanda Investigation Bureau in the implementation of plea bargain. As my colleague DG said recently, under Rwanda legal framework, the authority to initiate the plea bargain lies exclusively with the prosecution. Plea bargain is therefore a prosecutorial function exercised under authority and the supervision of the National Public Prosecution Authority as it is stipulated in the criminal law procedure. And it is also noted in the practice directions of the President of the Supreme Court governing the plea bargaining procedure that requires prosecutors, whenever possible, to initiate plea bargain negotiations at the earliest appropriate stage proceedings. Accordingly, it has been noted that investigators do not possess legal authority to initiate or negotiate plea bargain agreements, but they played a significant role in supporting in supportive and operational in nature. In practice, investigators may inform suspects about the legal possibility of plea bargain and facilitate communication between prosecutors, suspects, victims, and defense counsel. They further assist prosecutors by gathering and verifying evidence, confirming facts admitted by suspects, tracing victims, documenting losses suffered by victims, and verifying cooperation provided during the plea bargain process. For example, where a suspect expresses willingness to admit responsibility, cooperate with authorities, compensate victims, or disclose relevant information, investigators assist prosecutors by verifying the truthfulness, reliability, and evidential value of such admissions through further investigations and assessment of evidence. However, the decision to initiate plea bargain, approve its terms, define the legal qualification of offenses, and assure compliance with procedure safeguard remains exclusively within the mandate of prosecutors acting in accordance with the law and the judicial practice directions. This prosecutorial oversight is essential to ensure the legality, fairness, transparency, and credibility of the process. At the National Public Prosecution, the important is the protection of the victim rights. And we firmly believe that plea bargain cannot succeed without a meaningful victim participation. Prosecutors are obliged to work closely with investigators to ensure that victims are informed, consulted, and appropriately involved in discussion relating to the restitution, compensation, or other restorative measures. This collaboration between NPPA and the Rwanda Investigation Bureau has already produced tangible results. According to NPPA records, between 1st July 2025 and 30th April 2026, a total of 11,637 cases were successfully resolved through a plea bargain mechanism. Many of these cases benefited from effective coordination between prosecutors and investigators, particularly regarding victim participation and verification of facts admitted by suspects. Coming to the issue related to NPPA experience with plea bargain as a contributor to social cohesion, I can say that in Rwanda, justice must not only punish wrongful acts, it must also contribute to healing, reconciliation, and the restoration of social trust. One of the most important lessons from our experience is the value of acknowledgement of responsibility. Victims and communities often attach significant importance not only to punishment, but also to offenders' willingness to openly admit fact that they are accused, accept responsibility, and demonstrate remorse. Such acknowledgement frequently contributes to emotional closure for victims and promotes reconciliation within the community. In many respects, this restorative dimension reflects principles that historically informed Rwanda's reconciliation-oriented justice approach, including lessons drawn from the experience we had in Gacaca process court. I can say also that plea bargain increasingly facilitate reparative justice. Many negotiated agreements include restitution of property, compensation for damages, or other restorative measures aimed at repairing harm caused by criminal conduct. These outcomes often contribute to rebuilding relationship between offenders, victims, and the community. The continued development of plea bargaining and victim offenders mediation reflects Rwanda's commitment to a modern, efficient, and restorative justice system. I can conclude on that statement. Thank you, moderator.
Thank you very much for the enlightening discussion and contribution to this panel presentation. But what I'm learning from you, from the institutional perspective, is that plea bargaining is a pathway to social cohesion by the different elements that you provided, including reconciliation and other advantages that it yields to. And I like the presentation because it complements the RIB presentation, where it brings in mediation also as a contributor in different ways for the social cohesion. Before going further, of course, I will invite the representative from the Maitre from Rwanda Bar Association. I would like to know at which stage does the Rwanda Bar Association engage into the process of alternative dispute resolution approaches? Yeah, or which stage do you think it should get involved? Yeah, so thank you. The floor is yours. And I would also like to share some comment. I was reading an article, and one of the authors was giving an example of lawyers who do not support ADR approaches, and he was comparing them to surgeons when they meet their clients, whenever they meet their clients, and they only recommend a surgery. So I want to know what is the perspective of lawyers in regard to these ADR approaches, specifically the ones under discussion.
Thank you very much, moderator. Dear members present, as the Rwanda Bar Association, we have come to understand that achieving justice is not only about the punishing the wrongdoing, but also initiating all the mechanisms available to restore the humanity and the reconciliation. We, the lawyers, as you know, we usually engage in representing our clients before different levels, while as they undergo the process of justice. But as my previous speakers have just said, we are not left behind in as far as initiating this process of pre-bargaining process is concerned, because we believe that we cannot only rotate on the process of what we lawyers think we should gain or what we should achieve while representing the client. Mostly I talk about the fees which we get from the clients, but we should also think, we have thought of other different approaches where we can engage not only on achieving the fees from the lawyers, but also assisting the judiciary in getting in achieving the justice which should be required in as far as this topic of pre-bargaining is concerned. So you mentioned that we, the lawyers, where actually should we get involved in this process of pre-bargaining. There are different stages where actually we get involved. Mostly we, right from the time of the investigation, we, the lawyers, we intervene actually to help the clients to know or to access the evidences which have been labeled against the clients which we are presenting. So from the initial investigations, after analyzing the evidences which have been brought before the client that is being accused, we can be able to know actually how the process is going to move on, of whether we can immediately initiate or convince our clients to enter into pre-bargaining, or we can still go on to defend the case. So initially, even at the time of investigation, we, the lawyers, we help our clients to analyze the case, to analyze the evidence, so that it can help us to know if the case goes up the time of the prosecution, which way we should take, either defending the case as it is, or whether we can help the client to enter into the pre-bargaining. Also, even at the time of, from the investigation, at the time of arrest, definitely we also intervene, or also we participate to know at that particular stage if we can, from there, begin to convince our client to engage in this process of pre-bargaining. Actually, there are several stages, even at the time of the prosecution, where actually this pre-bargaining begins. It is where we put on much of our effort to see, actually, because from the time of investigation, most of the evidences have been concluded. So from there, we can be able to engage with our clients to initiate or to enter into this process of pre-bargaining. And more so, even if the case is being tried at the court, the lawyers still, we do engage ourselves in this pre-bargaining process, because during the pre-trial, during the hearing process or trying the case, there are several evidences, or much more of the evidences which may come in, and if you analyze that actually these evidences may pin your client, you can resort to advising your client to go or to engage in this process of pre-bargaining. So actually, all those stages, we the lawyers, we engage with the clients to assist in this pre-bargaining process. Thank you.
Thank you very much for shedding light on the role of lawyers, specifically the initiation part of it. We thank God that the lawyers have been baptized into ADRs. Usually, sometimes some of them have not endorsed it, but now we are grateful that slowly by slowly, they've embraced the whole process. Coming back to Justice Habarurema, looking at courts, do courts always have to accept plea agreements? And if yes, under which considerations do they accept the plea agreements? Do they always endorse the agreements? Looking at the rigorous process that has to be gone through. Yeah, if you could shed light on that, but also specifically, we would love to know, since the establishment or since the conception of this idea, what are the achievements?
Thank you very much, moderator. Honorable Chief Justice Emeritus, dear participants, it's a pleasure for me to present the perspective of the court in this process. For your question, you asked whether the judge who received the agreement of pre-bargaining has always to accept, or whether there are some issues which can push him to reject. I would like to begin by talking about a popular case in ICTR, which involved the prosecution versus Jacques Ambanda, who was the prime minister during genocide. In that case, you know, the prosecution has negotiated with the accused, and the agreement consisted in requesting the penalty of 15 years. The agreement was signed between the accused and the prosecution, and when it was presented to the court rejected it in consideration of the gravity of the offense and the consequences of the offense over the victim. So this shows you, when I come back to the Rwandan context, it shows you that this process, bargaining between the accused and the prosecution, it's an agreement which is signed, but which is subject to approval by the court. Therefore, the court may accept or reject the agreement. So you asked, what are the grounds of rejecting the agreement? So the court, as a guarantor of the rights of the people, the court assess whether the rights of the accused have been respected, whether the accused have been assisted in case of necessity, whether he or she requested the assistance, and did he receive the assistance, whether the right to know the charges, to know the content of the case file, to know the consequence of the bargaining, including the possibility of the impossibility of appealing. So all of these issues are to be assessed, and if the judge finds that the rights of the accused and the law and the regulations have been applied, the judge will approve the agreement and sign a court decision on the basis of that agreement. So, so far in our practice, we have not seen cases where the judge rejected the agreement, but it is possible. Let me give an example of possibility of rejecting the agreement. Imagine in a case where the accused was not informed about his right, the right to waive the appeal. and he signed an agreement where he does not know whether this is not appealable, then he signed it without knowing the consequences of what he is signing. Another possibility, it is when the agreement have been signed without considering the right of the other side. Because in these approaches, restorative justice approaches, we must bear in mind that it concerns both sides. It must concern the accused and the victim. So if the judge considers that the right of the victim have been ignored, he may reject or send the parties to negotiate again the agreement and bring it back to him or her for approval. So in a few words, I would respond that the judge who received the agreement is not obliged to accept or to approve necessarily what is brought before him by the parties. So with regard to the statistics, the statistics have been presented in the presentation of the rector, but I may say a bit about the statistics of these processes. We have two processes. We have the victim offender mediation and plea bargaining. Victim offender mediation is the recent approach of ADR in criminal matters, and since it was established, the total cases, it began in September 2025 till now. A number of more than 1,458 cases have been resolved through victim offender mediation. And this process have been established through the practice direction of the Honorable Chief Justice, taking the lead. It comes when this process have not been implemented through the investigation process before RIB or before the prosecution. There, the court may initiate the victim offender mediation and achieve the same result which would have been achieved during the preliminary investigation. So it's a good example of complementarity of institutions. What is not done through the preliminary investigation is done through the court in the presence of the parties, and the court asked the position of the prosecution, which may inform the court about the possibility of not proceeding with victim offender mediation, especially when the conditions are not fulfilled. So the prosecution can inform the court, and the process may be stopped or proceed with it. So it's a good case of complementarity between the two institutions, but the goal is achieved, which is to restore the harmony among the population and restore the harmony between the offender and the victim and the community at large. With regard to the statistics of plea bargaining, the plea bargaining have been installed in our laws, in the law of 2017, and the policy, criminal justice policy, which was implemented in 2022, began. So the practice, in practice, the first cases was developed in 2023 after the implementation of the criminal justice policy. So since 2023 up to today, you can see how the cases have been increased. In 2023, the cases were about 9,000 and above. 2024, it was 9,851. The following year, in 2025, it was 11,846. And in this year, 2026, we are up to date 12,123 cases. The total cases from 2003 up to date, we have 34,754 cases. So this shows you that since the beginning of these programs, there is an increase. And although we are not together with RCS here, if you push or ask the impact of plea bargaining and the VOM proceedings in the prison population have been decreased from more than 130%. Today it is less than 100. We are below low 100 prison population, showing you that this mechanism are having an impact in restoring harmony and peace among the population. It decreased the number of backlogs. It decreased the prison population. In general, it is a benefit to all of us as a community. Thank you very much.
Thank you very much, Justice, and specifically for bringing in the collaboration across institutions, which brings about restorative justice and social cohesion. My last question for the panelists, and I'll start with you, Justice, just in 1 minute. In as much as you have also mentioned the achievements and shared with us the statistics, which are significant, but still, what can we do as institutions to accelerate this process, looking at the benefits of plea bargaining, but also of victim and offender mediation? What can we do to accelerate the process? Because in as much as it has reduced case backlogs, reduced overcrowding in prison or correctional facilities, but still we have significant backlogs. So what can we do? And that question is a collective question for all the panelists. You'll be followed by the Deputy Prosecutor General, then Maitre Focus, and we'll end with the DG of RIB. Thank you.
Thank you very much for the question about what can we do as institutions in order to increase the impact of this mechanism among the system in general. As we know, through the presentation of the Deputy Prosecutor General, it is the primary task of the prosecution to initiate plea bargaining, and the task of RIB to initiate criminal mediation at the beginning of the process. So in our side, we think that we should do the best to begin at the beginning, to apply criminal mediation at RIB level, and increase the number of cases which are resolved at RIB level. If it is done, the few cases should be resolved again through mediation at the prosecution level. When I was discussing yesterday with the trainees at the RPD, they were saying that the reason why at the beginning sometimes alternatives are not possible is that when the case is beginning, the victim sometimes is not willing, or even the suspect is not willing to enter in the process because he have not yet seen what he's going to face. So once he passed a month in a prison, then he changed the position. So something which is not done through RIP can be done in the prosecution. And if the mediation, the criminal mediation is maximized at RIP and the prosecution level, it means that many cases would be closed without being filed in the court, and it will impact positively than it is done. But it is done, but more should be done. Things which are not done through the mediation, we can again profit in pre-bargaining. And pre-bargaining, currently, as we are using it, we have challenges. As you know, the prosecution file cases, and when the prosecution file the cases, they have to draft the indictment. And this is by law. The law says that the prosecution sees the court by sending the indictment and the complete file. And this hinder the implementation of the pre-bargaining, because they first file the case to the court with the indictment, and it is the court which will operate the screening and send back the list to the prosecution for pre-bargaining. So this is in somehow a double work. Something should be done, whether in the system, whether in the system while waiting the change of the law, but the practice can precede the law. Permit prosecutors to seize the court by sending the agreement, rather than sending the indictment and then being obliged to receive again the case which have been filed to the court and send the agreement. It is, when you discuss with prosecutors, and if actually it is true, it is a double work. It is a double work. It should be made easy to permit prosecutors to seize the court by an agreement. But so far, it is not done. I would request that it should be arranged to permit prosecutors to begin like that. And this is in the main mission of the prosecution, to to choose the way, whether to indict or whether to request the court to approve the agreement. So this will facilitate the task and will accelerate the cases. And if these are done, I think that if each institution is proactive, I give an example at the primary level, where they are competent for cases which are punishable by a penalty of less than 5 years. So if we maximize criminal mediation at LIB level, maximize criminal mediation at the prosecution level, we don't have cases which are filed in the court for litigation. If we maximize pre-bargaining for all those cases, we don't have cases for litigation in primary level court, except some cases considering the complexity, the nature, the circumstance of the case which are involved. Another thing which I would request, it is to sit and discuss whether it is the law and the practice directions allow that all cases are bargainable, but in practice, actors are reluctant. So they are bargainable, as we saw the experience from Justice Andrew, in consideration of the circumstance. I don't support that all cases should end in bargaining, but you can bargain any case. It depends on what you are bargaining. If you are bargaining a case of rape, where the offender is a primary offender, he is cooperative with the victim, he is ready to compensate, he signed 15 years, I'm wondering what hinder the authority to approve the pre-bargaining if it is illegal. if it does not have a negative impact on the community, you involve the victim, the community, and you apply the law, I think that we should rethink what cases should be involved in plea bargaining. But in consideration of the nature of the case, the impact of the case, and the circumstance in which the offense was committed, and the participation of the victim. Again, because we are dealing with restorative justice, whatever we do in our agreement, we should think about the victim. We cannot be happy to maximize the number of plea bargaining cases if the victim is forgotten. That would not be restorative. Restorative justice in Kinyarwanda, it is ubutabera nsana sana. How do you argue to apply restorative justice if you give justice only to the suspect and you forget the victim? Restorative should imply both the suspect, the victim, and even the community at large. Thank you very much.
Yeah, thank you very much. We can continue in the order, but just 1 minute as yeah.
Thank you, Madam. In order to continue to have maximum benefits of plea bargain and other ADR mechanism in delivering justice, it is important to keep raising awareness among Rwandan population so that they understand advantages of using ADR when offenses are committed. For me, it is recommended that government institutions as well as non-government organizations should continue to invest efforts in educating citizens about the benefits of these programs. I can confirm that the National Public Prosecution Authority remains fully committed to strengthening collaboration with Rwanda Investigation Bureau, Judiciary, Bar Association, and all justice sector stakeholders to assure that this mechanism continue contributing to a fair, efficient, and restorative justice system in Rwanda. And I can confirm that all prosecutors are now aware that this mechanism should be applied before using other mechanism. Thank you, Madam.
Thank you. In regards to what should be done actually to accelerate this process of pre-bargaining, I believe a bigger part lies within the hands of the prosecution, provided that the case has fulfilled all the conditions. Because we, the lawyers, most of the time, there's sometimes when we request for entering into the pre-bargaining, but you find that most of the time, the levels of prosecution where we are requesting for that process, they are somehow reluctant. And even for the time I have been handling the cases, I have never received a call from a prosecutor requesting me to come and enter into the pre-bargaining process with my client. It is we, most of the time, it's we, the lawyers, who actually push to initiate the pre-bargaining process. So I believe actually all the institutions here and we, the lawyers, should actually come to understand that this process is better, as it has been previously discussed, and we, the lawyers, we are ready to cooperate into this. We have been trained, most of the trainings which we receive annually, much of the time has been allocated to train the lawyers in this mediation pre-bargaining process. So the lawyers, we understand that actually achieving justice is not pushing the case into so many several stages, but what actually your client wants to achieve and at what time should be achieved. So we believe all that can be help to accelerate what we have. Thank you.
Thank you. Just to go straight to the point, as has been maybe highlighted by my colleagues here, we recommend 4 major interventions if we are to accelerate these negotiated settlement mechanisms. One is to continue working on clear, harmonized legal framework that define eligible offenses, roles, and safeguards across all entire justice system and institutions. That's number 1. 2, we need to dedicate, to have dedicated units and train the staff that will be working and facilitate this process of negotiated settlement mechanisms in our different institutions in the justice system. Thirdly, and this goes also with the second one, we need to keep working on capacity building, because we need to train our legal practitioners across the board to make sure that they are equipped with the necessary skills for them to be able to undertake these processes and fast track the processes involved. Fourth, we need to initiate victim support services to ensure informed and voluntary participation of parties, because they also have a role to play in this process. Lastly but not least, we need to keep working on public awareness. We need to extend public awareness to different actors, starting from the public and even to institutions, members of institutions involved, just to explain the benefit of these mechanisms and to ensure that we enhance participation of everyone, because everyone has to play a role. So to be brief, just those are the 5 major areas that we need maybe to keep working on if we are to accelerate the process. Thank you so much.
Thank you very much. As we come to the end of this panel discussion, allow me appreciate all the panelists for sharing their insights, but also for bringing important matters to debate in regard to the subject matter of plea bargaining, victim and offender mediation. There are so many key takeaways. But if we can, what we learn is that actually these ADR approaches are a bridge between retributive justice and restorative justice, which is really very key. But also there was emphasis on institutional collaboration for success in having restorative justice and social cohesion, which is very key. They were also generous enough to share the main challenges, the successes of mediation, that is, of course, offender and victim mediation, but also to share with us the practical challenges and the future pathways that we need to embrace. So thank you for that. And Honorable Chief Justice, looking at the time, we are past time, but if you allow, we could maybe have 1 or 2 questions, or we could end our panel discussion for the other, because there's another panel that will be coming after us. Thank you, sir.
round it off. Yes.
Thank you very much. My question is about the Rwandan culture, which whereby Rwandans, of course, they don't appreciate the issue about mediation or negotiation. Of course, supported by some studies which compare the ICTR and this ICTY pre-bargaining, whereby for ICTY it was a third, while of suspects, of course, involved in the pre-bargaining, while for the ICTR it was just 20%. So, of course, Justice Habarurema also highlighted the issue about some justice actors who resist pre-bargaining and they believe that justice is just putting the people in jail. So then the question about what measures to be taken against this culture or this bad culture, whereby, of course, justice is just putting people in jail, making them feel maximum pain. Thanks.
Thank you very much. Actually, my question is not far different from this one. I really wanted to add something. I have followed the presentation of the director of IDPD when he talked about the study that was conducted in 2001. And actually, the researcher discovered that Rwandan citizens were against these alternative dispute resolutions, more than 60%. And he was, in a way, optimistic, expecting that in between things changed. But you are the ones on the field. Can you please confirm to us that things changed? Beneficiaries of these alternative measures, do they understand what we are dealing with? So this is my first question, and I am asking this question considering the second objective of alternative dispute resolution policy. The second objective of the policy mentions that these ADR are exercised without ignoring accountability, punishment, and deterrence. That is the second objective of the policy. And I thought that maybe people do not accept the measures, maybe because they do not observe the achievement of this second objective of the policy. Thank you.
Thank you. In the interest of time, I will address my question to only one person, Justice Jean-Pierre. I would like to know the perceptions. How do you assess the perceptions of the victims on ADR when it comes to violent crimes? We can even mention the case of homicide, the murder cases. Do they express satisfactions or not? Thank you.
Thank you. We invite the panelists, and we'll start with Justice Habarurema. I think there were two questions addressed to you. And then the other question from the Justice, we will hear institutional perspectives from RIB, NPPA, and the Rwanda Bar Association, but in very brief. Thank you.
Thank you very much. I will begin by this question about the culture of legal practitioners about the use of non-custodial measures. I think that the lecturer at INES was insinuating about the culture of legal practitioners, prosecutors, investigators, judges, who are still reluctant in using non-custodial measures. For this question, I would think that we should change the mindset. We should change the mindset because, as the director, when in his introductory remarks, he mentioned that ADR mechanism are African mechanism. In other words, this mechanism are the Rwandan mechanism or African mechanism. We say ibi bintu byo gukoresha ubundi buryo butari imanza ni iby'i Rwanda. Bivuye ngo imanza ntabwo ari iz'i Rwanda. And if you look at the Constitution, Article 10F, it is a choice and orientation of the Rwandans as a whole to resolve all matters through dialogue. So, and the policy 2022 is the same. So who am I not to dance the same music with my fellow Rwandans? It's up to us, we actors, prosecutors, investigators, and judges, to dance the same music with other Rwandans and change the mindset. But, as I said, I don't urge the actors to implement this mechanism where they are not applicable. We need to use the discretion and apply it where it is applicable, and bring it when it brings a solution, not to cause the problem. Ntabwo twakoresha izi mechanism mu gihe tubona ari ziduteza ibibazo aho gukemura ibibazo. The same kirajya gusa n'icya afande uvuze ngo perceptions of the victims. Ibi bisaba research. It needs the research, the perceptions of the victims on the ADR mechanism. Perhaps it may be recommended to ILPD to go on with the question which was answered in the previous research, as Justice Marius said, the perception in 2016, when the perception of Rwandans, more than 60% were against. What is their perception today? I think that this would be answered through a study. But when you look at it, just when you ask one person at random, in the visit of the Chief Justice in Rusizi, we were informed that people are reluctant to come from Nyakabuye to come to Kamembe just for the sake of giving a pardon. Meaning that I don't know what you are doing. So Justice Andrew said, justice for whom? Is it justice for me, the judge? Is it the justice for the citizen? So we need to involve those the beneficiaries to make it theirs. Perhaps the research will show what can be done in order to attract Rwandans, because the justice is for them. Rwandans in the Constitution have accepted it. Barabyemeye. Baravuga ngo twebwe twiyemeje gukemura ibibazo dukoresheje dialogue. None ko abanyarwanda babyihitiyemo, tuzongere tubabaze ngo mbese mwahisemo ibyo mutazi. In criminal matters, your dialogue, it applies in all matters. No muri criminal matters, iyo nzira yo gukemura ibibazo in dialogue should be applied. Nibwira ko the Rwandan population should also be consulted and mobilized, and tell them that this is the best way to go. And this is our way. We come back to the root, because kuburana si iby'i Rwanda, gufunga si iby'i Rwanda. You can imagine the first prison in Rwanda was the Dizenefutranti. Dizenefutranti means in 1930, the first prison was established by Belgian. So before, kugihe cya Ruganzu, prison yabagaho. Kugihe cyande nande abami bose muzi mbere y'igihumbi, prison did not exist, but offenses existed. Litigation existed, but they were resolved in the Rwandan culture. Kufunga si iby'i Rwanda, kuburana si iby'i Rwanda, abanyarwanda bakwiye noneho guhindura mindset, bakagaruka ku byabo. So I complain that our culture have been stolen by Europeans. So the third question is about the accountability and deterrence, which was asked by Justice Marius. I support that. Using PB and mediation, we should not look at the suspect or at the releasing the suspect. No. Justice Andrew said it. We should look at both sides. Both sides. We give a penalty or we sign an agreement in which the offender is ready to be held accountable and to seek for pardon, so that we should look on both sides. The agreement should look at all sides. The suspect is accountable. The victim is repaired in such a way we should not lose anything. But I insist on mobilizing the people. Ba nyir'ubutabera ntabwo babizi, bakwiye kubyibutswa. Thank you very much.
Thank you very much also for reminding us the first prison that we had in 1930. And the Minister of Justice always makes fun of it, that we had the first prison in 1930 and the first law faculty, we had it in 1970s. So we had a prison without people knowing the laws. Yeah. So you can
continue. Mine is to respond on public perception. I can say maybe, as we all know, beginnings are always difficult. At the initial stage, it was not easy. People were reluctant to adopt these kind of negotiated settlement mechanisms. But the figures we have, year by year, can always tell the truth. When we started the mediation process after 2023, the first year we recorded about 300 cases settled through mediation at RIB. But this following year, we recorded more than 2,000 cases settled through mediation. And the third year, we recorded 6,000. And we have seen from our practical settings that we've seen some people have started even initiating themselves, requesting to settle their dispute, their criminal dispute through mediation in minor cases, and even trying to extend it to even to some major cases. If I remember one victim came recently to my office asking for a negotiated settlement for a case that was supposed even to go beyond 5 years past sentence, 5 years of imprisonment. Of course, we are blocked by the law, but we can see that people are increasingly adopting such kind of mechanisms. So the trend is promising. What we can say is that this is only 2 years using mediation process. Probably there are some members of the public who are not yet informed about the mechanism, the existing mechanism, and the benefit from it. So we still need to work on it. That's why we are recommending to extend, to keep extending awareness campaigns to different actors. Thank you so much.
Thank you, Madam. I think regarding victims' satisfaction with the ADR mechanism, the issue can be debatable. Some people already understand their importance, but there are still others who hold traditional views. This is why there is a need, as my predecessor said, for public awareness campaigns targeting people who still have a colonial era mindset about punishment and believe that punishment must necessarily mean imprisonment. Hakeneye ubukangurambaga byanze bikunze, natwe ubwacu byatangiye tutabyumva, ariko ubu tumaze kumva akamaro kabyo. Niba rero tutarabyumvaga, mwibaza abaturage, awareness irakenewe ahantu hose. Ni ngombwa rero ko inzego zose zizashyiramo imbaraga. Murakoze.
On culture and perception, a lawyer in the criminal case is either representing the interest of the victim or the side of the offender. So we have come to believe that actually when you are presenting the victim, most of the time, as long as the victim is compensated, has come to understand that there is no need to push to the offender up to the time when he believes that the offender is taken into prison. That's when he achieves the justice. But so far now what we see, either on the side of the victim or the offender, of course, in this process of pre-bargaining, the offender also gains in exchange of what should have been inflicted, either that is a punishment or not punishment, but in exchange of the punishment, there is something that the offender gains, and the victim is compensated. So what we see is that there is a bit of a change of the mindset on these two people, and we believe when it goes on like this, there will be a bit of a bigger change in adopting and understanding this process of pre-bargaining. Thank you.
Very much. Thanks again to the panelists and the audience. And we finally come to the end. But before, there's a comment from the Chief Justice. Thank you.
The Chief Justice and then the guest speaker also wanted to say something. So after the guest, yes.
Thank you. I just wanted to say one or two words. I don't have much to say, to contribute. But I just wanted to congratulate all of the institutions here that are represented. I think as the Professor Andrew, Justice Andrew mentioned, this issue of pre-bargaining started very small. I remember still when I was still in office, we received a delegation from University of Pepperdine, which was at the time working with the Uganda judiciary in pre-bargaining. And at the beginning we thought this is something just for Uganda and for this university. They are collaborating. It can't get anywhere in this country. But we encouraged it, and I'm so happy to see that it has really taken off, that it has the support of all the justice sector institutions, and to see the progress from 0 to many thousands of cases. And it is so pleasing to see the effect that it has reduced backlogs, it has reduced congestion in the prisons. So I think it is good to note that when our country decides on a policy, then everybody seems to buy in and to push it. And I have no doubt that even those obstacles or challenges that you are meeting in implementation will eventually be resolved as people get more sensitized. People will continue to buy in, and I think the future is bright. As Justice M.A. said from the beginning, this is part of our culture of resolving disputes amicably, of minimizing detentions and imprisonment. So it's just a matter of time that as it is in other countries, our disputes, whether criminal or civil, will eventually be more resolved through these peaceful means, through negotiation and understanding and restoration of relations, so that only a minimum of cases, or a small fraction of our disputes go to court. So I think that is the future. And again, congratulations for everybody for your contribution to this project.
Thank you. Just to say that if you are going to introduce any reform and it does not meet resistance, what that means is that the citizens are sleeping. I think the citizens are supposed to be alert 24/7. Because if you look at the constitutions of all African countries, judicial power is exercised by the courts on behalf of the people. So they have all the right to question anything that seems to be alien that is coming in. So it is our responsibility to explain, because we owe them a duty to explain to them. Now, I think that, as His Lordship Justice Rugege has said, I think Rwanda is doing very well on this program. And I say this because I was in the room that afternoon in 2014. We had Justice Rugege, we had the Honorable Justice Richard. He was Prosecutor General at the time, is now in the ESCJ. We talked and we moved out of the room, not even sure that anything would happen. So moving from there to where we are at, you realize that if you are going to do a project mapping, you have short, mid, and long-term interventions. So the short term has been achieved. I think we are in the mid-term of work. Now I think what we need to do is to think about the following. One, you cannot move together if you are not in the same accord. Are the actors in this room all in the same accord? Do we still have doubting Thomases in the room? Now, those are the first point. Now, the doubting Thomas also have a justification to doubt, because when they doubt and their answers are given, they go outside there and preach the gospel of the theme. We may now need to consider a communication kind of strategy for plea bargaining and victim offender mediation. Now, this communication strategy of plea bargaining and victim mediation, offender mediation, will speak to the following things. Break down the message in small bits that can be easily chewed by anybody in the language that is understandable. And each of the stakeholders should make a contribution in that communication strategy, because it is going to be the awareness kind of agenda, so that we all read from the same page. Because if we don't have where we all read from to preach the gospel, everybody will preach the way they understand, so there will be inconsistencies. Somebody will say this, the other person will say this, so there will be a bit of confusion. So it is important that we speak from the same page. And lastly, I want to again thank the organizers of this. I think this has come at the right time. It would have not come much earlier, because when you have a symposium after you have done something, you talk about something you understand. It would have made all the difference to come here to speak about something that we have not tried out. Now that we have tried out, we are speaking with experience. If there are potholes we have met along the way, those ones can be filled. We drove with my brother, Justice Eme, yesterday from Nyanza. I literally counted the potholes. They were literally, I didn't see the potholes. So what that means is the people of Rwanda are good at filling potholes. So if there are any potholes we have so far made in this exercise, let's fill them. And the place to fill them is here and today. Thank you.
All right, ladies and gentlemen, please a round of applause to the panelists. Please, you can resume your seats. Thank you very much. We can say they've done justice to the theme they were supposed to discuss on, and thank you very much. We're indebted to your time and thoughts in all this. So, well, we are running behind schedule. We are definitely out of time, and I will definitely introduce the last panel. And before I do that, I want to recognize the guest of honor that has joined us shortly. Lady Justice Alozia Chanzele, please welcome her. I appreciate her for coming. Thank you very much, Your Ladyship. We have transitioned very well. You found the first panel and almost concluding, but we've been doing very well. We had all the presentation, including our keynote speaker, our guest speaker, Professor Justice Andrew Kauka, in that sense. So without further ado, I want to introduce the last panel, and it's going to be moderated by Professor Dr. Dennis Vichesha. Please come on the stage as we do, as introduce you. He's an associate professor of transitional justice and the Dean Emeritus School of Law, University of Rwanda. We'll end it there. As I told you, we have a QR code on your leaflets there. You can scan and see the entire CV of them. It is going to be the moderator of this able panel, and he has told me he's going to do it as a teacher, so they can do it even in 15 minutes. Isn't it? That is it. And then he's going to be joined by Rector Dr. Eme Muyoboke Karimunda, Rector ILPD. Please join the stage. And then Professor Dr. Elvis Mbembe, ED IPIS. Also, please join them on the stage. They're also joined by Miss Ariane Inhesha, the Country Director of International ALAT. Please join them. And lastly but not least, Mr. Rwagasani of Beniraje. Please join them on the stage. And please give them a big clap as they come up here. And we're definitely happy to hear from them. So the floor is yours, Mr. Moderator.
Yeah, thank you so much, moderator. I'm very glad to moderate this panel composed of academics and even people that are in the work of NGO, and the theme is also very interesting, building knowledge and skills around ADR in criminal matters. Every word in this theme counts very heavily. Building, do we have the ability to construct fertile grounds for ADR in criminal matters? Probably the answer is yes. Do we have the raw materials? We are going to discover this as well. To approach these questions, main two questions, I have oriented our discussion following the following proverbs that can orient our discussion. One is that knowledge is like a garden. If it is not cultivated, it will not be harvested. This is a Guinean proverb, an African proverb. The second proverb is also an African proverb from DRC, a single bracelet. These things they wear sometimes on the legs, sometimes on the arms. A single bracelet does not jingle. It cannot make sound. So you only have it have them make sound, not one. So this means we need many people to discuss, and probably this is why we are here. If you have knowledge, it means you let others light their candles in it. I would like to begin with this gentleman from Veniraje, Gwagasani. We are yet to know the work you are doing, but the little information I have is that you have dedicated yourself, your time, towards promoting Rwandan heritage and cultural values. Can you trace any tradition-based practices similar or equivalent to ADR mechanisms in criminal matters that can inspire the present practices of ADR mechanisms in the country?
Thank you so much for the question, and allow me this time to discuss according to the theme of the day. Actually, Rwanda had been a country with a justice system well structured as a state nation. So I think using the word traditional will just keep our national values being those of the time of kings, but these values are legacy that would guide us now and even in 100 years to come. So these values are not traditional values. These are national values that had been used and of course currently are now one of the solutions. So taking example from the national values related to the justice system, as we know, first of all, there is one principle said, Rwanda is a victim of any case between A and B. If I have issue with you, we just think before we discuss anything, Rwanda as a country will end up being the victim of this case of me and you. So how can we now fight against the cause of this issue so that Rwanda would be saved by me and you. That principle guided our parents at community level. So we can even trace another way, another example, another practice, value. As long as we see that we are all concerned, not me as a judge, you as a victim, as long as you have issue, Rwanda is a victim now. We had also what we call preventive correction method. In Rwanda,
Braddock, I would be very happy if you maybe bring us the regional expressions in Kinyarwanda and then you explain.
Okay. Principle which is u Rwanda ubwarwo iyo mugiranye ikibazo hapfa u Rwanda harengana igihugu. Naba ari igihugu ciye urubanza naba ndi mukuru iyo umunyarwanda ajyanye ikibazo n'undi ikigenda bwa mbere n'u Rwanda nicyo kigira ikibazo. Bivuze ko twese biratureba. That was the principle number 1. The second one was preventive correction. Kurinda igitera urubanza nibwo bucamanza mu Rwanda. Guca urubanza ni uguca ikirutera. Preventive correction method. Kugira ngo hatazaba urubanza tugomba guca igitera imanza nibwo bucamanza mu muco w'igihugu. So guca izatangizo ahubwo ni ukurinda ko imanza ziba. They do that preventive correction through awareness and live life of a justice system using kirazira. Bashyiragaho ubwo buryo bwo kurinda ko haba ibyaha kugira ngo batagwa mu manza, bashyiraho uburyo bwo kumenyekanisha bimwe mu mategeko ariko babishyira mu muco. The lifestyle of our people was itself one of the procedure of preventive correction. Kirazira kugira gutya. Aho umuntu nyarwanda wese agenda abazi amategeko n'amabwiriza y'ikintu kizira gukora, icyitwa kwinjira mu nkiko z'undi. Kirazira kwinjira mu rukiko kuko mu rukiko ubutangiye kuburana n'undi muntu. Inkiko z'igihugu turazizi ko ari aho igihugu kigarukira. N'umuntu agira inkiko z'uburenganzira bwe, ngira ngo uyu munsi babyise uburenganzira cyangwa se rights. It was prohibited kujya mu burenganzira bw'undi muntu, kwinjira mu burenganzira bw'undi muntu, kwinjira mu rukiko rw'uwundi aho jye nawe duhurira singomba kwinjiramo kugira ngo tutabyara kuburana hagati yanjye nawe, kuko mu rukiko iyo winjiyemo kiba gisigaye ubwo ni impaka. Tugomba rero guca impaka twirinda kwinjirana mu burenganzira bw'undi. Umunyarwanda yabaga azi icyo yakora ngo atinjira mu rukiko rw'undi. So kirazira ya lifestyle. Ikindi, the justice system of this country since then was based, it was community based and family based. They had ubucamanza, uburyo bwo gukemura impaka kera byari bishingiye ku baturage cyane cyane mu muryango, habamo umuntu bita abo bitaga ngo abarenge, umurenge. Aho umurenge w'umuryango cyangwa se ushinzwe gukemura ibibazo mu muryango iteka abazi ibera mu muryango bakabikemura hagati y'umuryango bitararenga ngo byinjire umuyobozi cyangwa se ku mutware w'umusozi. Uwo murenge rero igihe habaye ikibazo abanyarwanda bombi b'umuryango umwe cyangwa se basanga ari umuryango utandukanye n'undi bakagana umurenge kugira ngo abagire inama. So the justice system was family based in the community. Agakemura ikibazo mbere yuko kigera ku muyobozi nk'uko bavuga ngo gicamuke mbere ko kigera mu bucamanza iki gihe.
Does it have any relationship with the Umurenge as an administrative entity we have today?
No, Umurenge was a person. Umurenge urengera rubanda karuhoza mu bumwe. Umurenge bitomuka ku kurengera, to defend. Umurenge urengera rubanda karuhoza mu bumwe nuwagomba kumva ikibazo cyabaye kare akayikemura muri urwo rwego kitarinjira ngo kijye mu bayobozi cyane cyane uhereye ku muyobozi w'umusozi. So ngira ngo nabandekeye aho.
Thank you so much. Now I'm coming to Dr. Karimunda, who is mainly known as a person that has worked in the judiciary for many years, but also as an academic. Probably we would need to know, other than having many people say something about ADR. How do you understand ADR?
Well, the ADR is alternative dispute resolution.
Can you explain more?
I think ADR.
You need to explain more because someone said even it may be African dispute resolution.
ADR is known today as alternative dispute resolution officially, and there are many components within this label for ADR. Some related to criminal matters, as the one we were discussing, pre-bargaining, victim offender mediation, some related to civil matters, some others related to commercial, and even in commercial matters you have some ramification, you have arbitration, negotiation, and negotiation, and so forth. But I think the question of ADR is rather why are those mechanisms of justice called alternative? I think that's where lies the question. Why are they alternative? So they are alternative as regards to the main mechanism of offering justice or dispute resolution. Every institution of justice is in charge of resolving a dispute. So if you consider the justice chain, everyone in justice sector is in charge of a dispute resolution. So now we have the main model of a dispute resolution, which is litigation. And we were taught that litigation has to be the main model of dispute resolution. And therefore, anything which is resolving the dispute, which is not litigation, becomes alternative.
Do you think they should keep that way?
That's the problem. That's the problem because, as Mr. Badrock was announcing, there is now something you might call in today's African society, including Rwandan society, we have a two-tiered justice system. We have the justice system for the people like you and myself and all the colleagues here who are informed about their rights and who can be informed about their rights and who understand this process of litigation and who can even enjoy the process of litigation. At the same time, we have a huge number of our people who are in the villages who don't understand what we are doing. Who they see us in the black robes, pronouncing Latin phrases, and going through institutions which are guarded by security forces. For entering, you have to be checked several times. whereas you are going to claim your right. And the citizens, they are lost. They don't understand. And sometimes they are our own mothers, they are our own brothers. When they come to us, they find us completely different. Even the setting of the court, when you enter the court, you have to stand up. And if you don't stand up, the judge has the power of putting you in jail. For you cannot get out without asking permission. So that's the problem we have. The citizens don't understand what we are doing. And we pretend to be knowing what we are doing. And that's now the question is, should we continue this way? The best way should be to either to bring the citizens toward what we are doing, or to join the citizens.
You should join them, because you are their servants.
So now, I think Justice Andrew made it very clearly. Now the Constitution says that every justice is delivered in the names of the citizen. So we have already an underlying principle. Now
La justice est rendue au nom du peuple.
So now the citizens, they don't understand what we are doing, whereas the justice is delivered in the name of the citizen. And therefore, I think Honorable Chief Justice, I don't remember the session where we are, but Honorable Chief Justice Urgege was putting forward that we should not continue calling this mechanism alternative. And it is wrong to call them alternative. We should rather call them appropriate, because they are ours. They belong to us. We call them appropriate. And you heard Justice Andrew saying that in the Chief Justice Forum, they said that this is the original dispute resolution mechanism, the African dispute resolution mechanism. So I think we should understand first the principles which are enshrined in our Constitution. This justice is delivered in the name of the citizen. That's why. We meaning that every justice actor is operating in the name and on behalf of the citizen, is accountable to the citizen. Now the second question, which was very well put forward in the presentation of the keynote speaker, is it justice for who? So the justice actors should not confuse themselves with the file they are analyzing. So if you confuse the file with yourself, then you are doing justice for yourself and forgetting that you are delivering justice on behalf of the citizen. So now, if you are delivering the justice on behalf of the citizen, the question is, so the main mission of a justice is to increase peace, because judicial institutions are part of law enforcers. All law enforcers are in charge of increasing peace within the society. So now, if a decision of the justice is expanding antagonism between the parties who came to the court, this means that the judge is not reaching, his or her mission. And if the judge has delivered the best decision, based, I don't know which case law, from England, from the US, from Australia, from Cour de Cassation de France, wherever, and now he reached a decision which has increased the antagonism, then the judge, in fact, has gone beyond the principle that Mr. Badrock was mentioning, the principle of where the role of the judge today, the role of any judicial officer, is that the role that had Umurenge in our previous culture. So every judicial officer, every justice actor should understand the role of Umurenge as a peacemaker within the society. So now, if I have a case between you and myself, and I have to move out of the city because I don't want to see you in the face again, because I have lost my case against you, then the judge has not fulfilled his mission. And in my understanding, that alternative dispute resolution should, first, should be renamed. Second, should be adopted, and willingly, for saving even our own societies. We see, if you are alone, we see that this model of litigation is eroding economies of Africa. So he was mentioning that they were spending $9 per inmate per day in Uganda. So is Rwanda. So now we must ask ourselves questions that are spent by prosecutors, by investigators, by, I don't know, Rwanda Forensic Institute, going in through these processes of finding, the culprit. And if now we take the example for the witch woman who confessed and who, even if we bring the brightest, forensic, researchers, they could not have the evidence for this witchcraft. But the witch has confessed, and he's ready to face justice. And we know that the modern justice will not lead to accountability of this witch. So I think we should give value to our own culture, give value to our own tradition, and see how we can review the legislation, we can review the institution, and we can review, we can upgrade the mindset so that we deliver the justice that is expected from us by the citizen.
Thank you so much. I shouldn't be liable for not having started with a lady, because they usually say ladies first. But now this is your turn, Ariane, as a person that is very well experienced in designing ways of peace building, conflict resolution, good governance, not only in Rwanda, by the way, but even in the other countries considering Great Lakes region. Can you share your experience related to the application of ADR mechanisms in peace building and social cohesion?
Thank you very much. Thank you for having me here. I thought I'll be the odd one out, not being a law practitioner, but I was happy to see that I am among peers. Like when Justice Andrew insisted on reconciliation, community impact, and I would add also healing, because that's also us as peace builders what we aim at. In terms of ADR, I think you guys are taking our jobs actually, because peace builders and peace building organizations, and more specifically in a context where they are under the civil law systems, where ADR is not does not have space or is not included or recognized. Most of the time you would see that civil society organizations are the ones that support or set up ADR mechanisms, and most specifically mediation groups. And these are community-based. You would see that the mediators are selected by the communities themselves. They identify elders most of the time, or people in their communities that they see themselves in, who are wise and who they trust that they will deliver, decisions that work for not only for the parties but also for the community. So there's a lot of ownership in those mechanisms when they are built from the community. And you'd see that when they work, of course, the community also serves as an accountability system, because the decisions are taken in public and everyone is involved. And also you would see that there is trust in the mechanism. So how do we then, as civil society, work now with systems such as when it becomes formal, when mediation enters informal systems, and where the community did not select the people who will be delivering mediation, and how do we ensure that the mechanisms are trusted? That's my question to all of you also. So I think because this session is about knowledge and exchange of experience, this is where maybe peace builders such as us, we can also come in terms of accompanying practitioners in their behavior change. Because when you change systems, you start by changing attitudes also and behaviors. It's not only understanding of the legal implications, but do they really understand that we are going to go from punitive to restorative? How will they, as actors, then comment ils vont émaner ce changement? How will they reflect that change? So it is a long process, and I think it would be a long process in which we all are, where we have to really build capacities in active listening, in conflict sensitivity, in even psychosocial support, because when we are talking about human interactions, and as Justice Andrew said, sometimes it becomes very emotional, and you also bring yourself in the process. So how do we bring all these actors who will be now engaged in these processes to not only preserve themselves, to really hold their own when they have to arbitrate, negotiate, or mediate between parties, without bringing their own amarangamutima, I don't know how you say that in English, in the process. How do they help, even in the small attitudes that we see, because we always talk about the initial contact as the start of building trust. Sometimes in our institutions, and of course not all, you can enter and someone will tell you, "Hongao." And then you spend hours. No one has asked you what you are coming to do. No one has asked you if, what you need. And you are coming in a state of emotional stress, and you need help. And the fact that you just spend the day there and no one has asked you, there is a loss of trust there. There is also a loss of human dignity. So it will be a lot of steps in terms of learning and how we deliver these ADR mechanism or ADR practices. And I think it would be, and the learning will also come through what a lot of people have insisted on, evaluation of practices, like periodic evaluation of how these mechanisms are working, what are the best practices, who is delivering the best so that they can share their experience, etc. So this is a long process that would need a lot of means.
I think what I learned from you is that ADR needs a multidisciplinary aspect when it is being handled. Building on that, do you have any advice probably you can give to the policymakers that are involved in the planning for ADR and the other related work?
The advice, that would be presumptuous, but for me, the recommendation would be that we work closely with each other to learn not only from those who have worked in mediation and in other settings, but also to exchange on how we bring the population to embrace this mechanism. And the awareness of it is not only to know that it exists, because Rwandans, there's a lot of us who do a lot of radio shows and awareness raising, how do you call it, tribune d'expression populaire, where we do awareness raising. But it's also for them to believe it. It's so difficult sometimes for our populations to fight for their rights, even when you tell them that you have this that is available to you, to really go and defend it, and because they are in front of someone of authority. So when I talk about behavior change, it's both ways, for those who are delivering, but also for our communities as well. So a lot of efforts should go in this awareness raising and behavior change, and also in a lot of evidence-based reforms, because now we are starting. It's a long road ahead, and we will need really to invest in research and evaluation, as I was saying, so that every year we come back and say, maybe here we need to tweak it a little bit, and maybe go this way rather than the other. Yeah.
Thank you so much, Ariane. I'm coming to Prof. Elvis Mbembe. As an academic, but also you are wearing two hats. Also, you are in peace building through IPEACE. What do you think is the role of academics in this journey of implementing ADR mechanisms?
Thank you very much, moderator. It's really a great pleasure to be here in this on this panel. It has been very fascinating. I don't know if you noticed it, but for me it was fascinating to contrast what I assume to be the age of the speaker over there, and how it took us back in time, explaining us things that happened many years ago. So it means that we keep learning, and also I would like here to share from an academic perspective what I believe could be the role of universities. I have developed certain number of talking points on this, but for the sake of time, I would just like to summarize and talk about 3 of them. And I'll start with the one I consider as very important, given the discussions that we have had since this morning. There is a point that Ariane has just mentioned. They mentioned about the civil law, which is legal culture. As academics, one of the things that we have to do, what we do at universities, is to shape legal culture and professional mindset. This is something very important because I dedicated a few weeks of my PhD thesis trying to find out how difference in legal systems impacted the attraction of foreign direct investment in Africa. And during that research, I discovered how deep a legal culture is. And just to make it easy, I concluded to illustrate it that it is like an operating system of a computer. When you have a MacBook, common law concept like the one we are discussing now, this requires a deep intervention of universities in shaping the mindset of the people that we are training so that they can embrace this. I was even more shocked when I was given the task of teaching contract law. When you compare our decree law of 1888 and the law of 2011 governing contracts, you find immediately that there's a very big difference in defining even what is law, what is contract. The constitutive elements are different, and some of them have even nothing in common. So that only tells us that however much we are trying to address this issue, we need to address that thing of difference in legal system. And that is a role to be played by the law school. Another role we have talked about here is research. From the room also we had questions. If I can remember, one of them was, okay, so far we have had more than 30,000 cases. So what? Have we seen any difference? This should speak to academics in the room. This is an area to explore, to go and find these data, see, okay, this is what has happened. Has there been any real impact? Can we empirically demonstrate that the recourse to plea bargaining has helped us reduce prison overcrowding. And there are many other questions to address. The third is also very important as we're discussing about, is it alternative, is it African, is it appropriate? So all these things, again, we need academics. Our role is to bridge global experience and local realities, meaning that we have things from all over the world, from different systems, from different countries. Then we should be the one to see what is good in a way of customizing, whatever it is, African, alternative, but does this fit our local realities? Fitting the local realities means it responds to the problems that our people, the citizens, face, because importing a system, importing a mechanism that comes not to resolve but to add more issues is not really something we could wish. So I think I would like to stop here. These are the three main points I wanted to highlight.
Thank you so much, Elvis. I'm coming back to Rwagasani. I'm assuming that there is much to borrow from the cultural values as we implement the ADR mechanisms. But do you also anticipate any challenges in borrowing a leaf from our cultural values? And if you think there are some challenges, how do you advise these challenges can be mitigated?
Thank you. Those challenges for me and others would be responsibilities for us to address. Borrowing from preventive correction method I've said, actually correcting a Rwandan would not only happen in a prison, it would have started from correcting a normal citizen in Rwanda. So for that one who is Kinyarwanda byita kurengera, kurengera urubibi ukaza kurengera n'inkiko hakurya. Kurubibi, urubibi means the edge of your right. So kurengera, violating the right at that edge, and you end up hitting the right of someone else. Ubwo nukurengera urubibi warenzaho ukinjira mu rukiko rw'undi aho mugabanira ugatera impaka. Every Rwandan should live a life of self-accountability. Ibyo bintu si iby'i Rwanda. Correctional services, abashinzwe kugorora abanyarwanda ntibakwiye kubagororera gusa muri gereza. Bakwiye kubanza kubereka uko bagororwa, bakabagorora aho bari, unaniranye bakageraho bamurindira bamugora kurushaho. So preventive, icyo nicyo tubona ko dukwiye kwinjiramo as a responsibility, also as a challenge. Biduchallenge kuko dukwiye kuba umuntu abanza akagororwa, uwo binaniye abe yereka uko agororwa, uwo binaniye akajya kugororerwa ahiherereye. Tukarinda ko abanyarwanda barengera, kurengera amategeko, kurengera mugenzi wawe, kurengera uko ariko kose kugeza ubwo urenga urubibi ukinjira mu rukiko ugatera kuburana cyangwa se impaka. Icya kabiri, the second one, someone I said about the prison of 1930. Even before, we had our recovery correction method called inzira ya muhekenyi. Inzira ya muhekenyi, one of the ubwiru musanzwe mubisoma inzira ya muhekenye ni imwe mu nzira y'ubwiru yerekana neza uko u Rwanda rwakosoraga no kurinda. Inzira ya muhekenye kurinda ko imbuto y'u Rwanda imungwa ihekenywa. So one of ihaniro ry'u Rwanda ubu ntabwo hakiri mu Rwanda ryabaga urenze gatoya Akagera igihe wakoraga icyaha uri mu buyobozi bukuru warahawe kuyobora uzi neza iby'imiyoborere ugahemuka bakujyanagaho bita Kabwera ukitwa imbwera ngo yigize Kabwera ni hano hakurya gatoya muri kilometero nke urenze umupaka wacu bakakureba yuko usobanuka urimo kugenda uhindura ibitekerezo bakaza kumanuraho bita Bwera Nyange utangiye guhindura ibitekerezo ukabana n'abandi aho hose ni ihaniro ni correctional service ukaza kuva Bwera Nyange ugaca mu misozi n'ishyamba rihari ukajya mu kindi gice cyo hepfo cyegereye aho bita kumuguruka.
But what could you do there?
Not really gufungwa, ntabwo ari ugufungwa, but that was a correctional service. Means it's a training wing to recover the righteousness, no kugororoka. Wigeze kuba intore urakosa ubwo ntabwo ubukibaye mu bantu kuko wahoze uri umuyobozi ni refresh course ugomba kugenda ukajya ahantu iherereye noneho ugaca muri ibyo bice byose ariko iyo unaniranye ntabwo ugaruka iyo babonye ko ntabwo guhinduka uhanirwayo kubera ko hari igice cy'Akagera bagomba kwambuka kabagera ko bageze ku rwego rwiza ubwo ariko twazabireba. That was just some details about
but you need to explain a bit. Could you meet some people maybe to talk to you about values?
Yeah. There were some people already trained for that process until you really, let me call it, you really win that race, that test. Yeah, so it's another process. It's called Inzira Muhekenyi. When you check on the Google, you will find Inzira Muhekenyi in Kinyarwanda. Ikirinda imbuto y'u Rwanda guhekenywa. Ikirinda imbuto y'u Rwanda kumunga. Ariko ibyo bakabikorera umuntu wabanje gutozwa akagororoka. Mu Kinyarwanda rero bakavuga ngo iyo utayobora urayoboka. Iyo utayobotse uragororwa.
Could you repeat that?
Mu Kinyarwanda biroroshye iyo utayobora ku rwego rwawe aho uri urayoboka. Umuyoboro abayobora beyemeje kunyuzamo ibitekerezo. Iyo bagushyizemo ukagorama mu muyoboro bagukuramo bakajya kukugorora. Iyo utayobora urayoboka, iyo utayoboka tse uragororwa kugira ngo umuyoboro udatera amagomerane ibitekerezo byiza bituruka mu buyobozi bikananirwa kugera ku baturage. Challenge. Okay.
Yeah. You can explain. Maybe it is Andrew. You should be translating to him.
Okay.
Otherwise, the story is more interesting when it is in Kinyarwanda.
Yeah. When you are.
But again, remember we don't have enough time, so you can summarize.
Yeah. Maybe somebody will be nearby him. Huh? So when you are not leading at certain level, you follow the leadership. If you don't do so, you will be corrected somewhere. It's a process in the country, and it's a principle. The last one, let me quote the last one. We have what we call gupfundikira.
And so the last one, huh?
Gupfundikira urubanza. The whole process of umurenge guhuza abantu kuganira, discussion, dialogue within the family or at a certain level, we end up at the final hearing. The final hearing, we make sure that No one is, A is not winning B, but we are winning the cause of that issue between A and B people. So winning the cause of that issue means A and B are not guilty. Of course, someone will be punished, but the cause has to be removed. After that, they are given a certain 2-3 weeks. Bakohereza bitwa inchunizi. Inchunizi ni abagomba kureba yuko nyuma y'urubanza abo bantu koko biyunze cyangwa babaye hamwe bakomeje ubumwe bw'Abanyarwanda. Urubanza rw'Abanyarwanda iyo rurangiye ntabwo rutera impaka n'inzigo, ahubwo iyo rurangiye iteka habaho mbere yuko barupfundikira habagaho abacunga ko babantu ku musozi koko cyangwa se bakomeje kubana nka mbere. There will be some people after hearing the final hearing to follow them, to check on them that they are now in the same, let me call it the basket of unity, to recover the unit that has been lost during the case. Nyuma y'icyo gihe rero bakabazana bagashinga inkingi, igiti, umurenge ubwo niwe uje kubikora, bagashinga inkingi kuri uwo musozi aho bari, akenshi babaga cyangwa se bikoreye munsi y'umunyi cyangwa se igiti gihari kinini gishoboka kibakingira izuba, bakakizengurutsaho umugozi bita agacaca. Babiri bakicara mu gacaca bakaganira, barangiza bagapfundikira wa mugozi kuri cya giti. Bo bagapfundika urubanza, umurenge akaza nawe akabapfundikira bwa kabiri, akabapfundikiye urubanza gutyo. Noneho babagabo bakongera kunywa ku nzoga, kujya gusaba abageni, ariko hagati yo kumva case no gupfundikira urubanza ntawe gutumira, ntawe kwegera, baba bareba yuko uri mu nzira za nyazo, kuko ubucamanza bw'igihugu bwari bushingiye cyane kuri sosiyete no kurengera igihugu. Now, the final hearing, after final hearing, there will be to follow up, and of course they bring a piece of wood at the end of the day, and a rope, they sit in between, and they tie the knot of unity, so that they will bring their value in the community. So the last but not least is the trust of those people, umurenge, in charge of justice. Kwizera, icyizere bagiraga muri abo bitwa umurenge, muri abo bitwa abakuru, muri abo babahuza kuganira. Ntabwo bo bari bameze nk'umwe utakiza ko bazafata urukwavu bakarukuramo inzovu. Babaga babizeye kubera ubwanga mugayo. Ubwo rero natwe muri justice yacu dutoze abaca imanza b'ubwanga mugayo, n'inshunizi zibikurikirana zikabimenya z'ubwanga mugayo. Inshunizi ubu ngubu ni nk'abagenza cyaha, bagenda bacunga bamenya iki cyabaye hano, iki cyabaye hano, bagapakaginga neza, bakazanira umurenge agatekereza kabiri, akazana bombi bagahuriza hamwe bagaca urubanza. So trust of the system and trust of judges or people in the justice sector is very important for the justice system itself, structure. So that was very important for our people and for our culture, and they live that life is the life of justice, where we bring up the unity. So currently, we would better train our people in the justice to be trustful, not expecting them to turn a hen into an elephant, as said. Thank you so much.
Yeah, thank you so much. Yeah, we have very few minutes, so the time that is remaining, I need to ask 2 questions, and maybe they are related. One, I'll ask Aimee. I can see your efforts to make sure that you help ADR in Rwanda, including this forum that has been initiated together with IPs, but do you have any other contribution today or tomorrow? Any support from the ILPD, the institution you represent today?
Thank you, moderator. And I think the question is the role of ILPD in promoting capacity building in the area of ADR. So the Institute of Legal Practice and Development it has been, of course, mandated to empower, starting first with the justice sector. That's the mission for the institute. And we had an issue when the plea bargaining rolled out a couple of years back, because by then myself and the Justice Harrison and the PN Tit and Michael Kalisa, we were entrusted to move forward the agenda for ADR, but we did not, it's plea bargaining especially. But before plea bargaining, we had also the mediation, which is led by the Honorable Chief Justice Emeritus. We have a committee related to mediation. But mediation, I think, was doing better as far as awareness is concerned. I remember the Chief Justice, although he should be enjoying his retirement with his grandkids and be resting more, but he made a crusade throughout the entire country to explain the relevance of ADR to the judges, to the prosecutors, to the registrars. So all the numbers we see today are in fact a result of the effort the Chief Justice made. I remember traveling with him from here, stopping in Musanze, sleeping in Rubavu, coming back, going with him in Tejega Sabo, going with him in the southern province, explaining that we should move away from exacerbating antagonism among litigants and bring the litigants together. And by then mediation was, we still have a small project in partnership with the judiciary from Edwards Mediation Academy, which is giving the basics on mediation, but which is not yet really our own mediation. We studied mediation, the principles from California, and sometimes we find that they are not fully customized. The role plays are not really related to our own history. But we do with what we have. We move with what we have. And as I'm speaking, I believe that the representative of the civil society who are here are understanding the concerns. So we still have an issue of the number of skilled people within the justice sector. Many of them are not yet empowered. So by 2023, we started now a new element of ADR, which is a plea bargaining. And together with the committee, which I mentioned, we're very, very worried that we're going to start something whose future is not fully guaranteed because the people are not empowered. So we tried to get people understand that they need to support this move. It took time, it took processes, it took questions and whatever, until recently we got 2 organizations who I think made the project understood by other stakeholders as far as capacity building is concerned. We got also a very good, I might say the best opportunity in the Ministry of Justice, the leadership, the top leadership in the Ministry of Justice that understands this move. And now we have started, we started this week, last Monday, we started the first cohort of the nearly 400, to be maybe 470 in total, maybe. Starting with 420, TB and the TGI, all the prosecutors, the judges, and the defense counsels. So now we had an issue of we are going to teach plea bargaining and the victim offender mediation, but what is the foundation? So that's how we started 2 days. We work with the organization of Venirage. It is a big team. He's the boss, but it is a big team of people who have these skills. And so we brought a couple of them, and now they teach these values the first day and the second day, and the 3 remaining days, they go in a plea bargaining stricto sensu, a victim offender mediation stricto sensu, and they end up with role plays. It is a 40 hours intensive training, and we believe these 420 will constitute the basis of at least moving forward with the ADR agenda in the criminal matters. And maybe it will reduce also the risk, because we are running a high risk of repeat offenders if we do nothing. So, and if we get a good number of repeat offenders, it will jeopardize the entire policy of plea bargaining, and even it might negatively impact the criminal justice policy. But as we are doing this, we should ask the question that Professor Elvis was asking itself. What we see is that academia is not necessarily following. So many curriculum in the universities, they're not following. We don't see really enthusiasm within academic institution. So we have started inviting these justice actors who are trained within the institute. We have now started inviting also lecturers from the Faculty of Law to join. I think we have a couple of them also in this symposium, so that at least they understand that they have to build theories around this. But as we are moving forward, there's something which Mr. Jean-Marie mentioned, which is very important in my humble view. The legislative barriers to move forward this agenda. So Justice Andrew mentioned that he met the Chief Justice sometimes in 2014. By then we were really, I think, we had a fully civil law mindset by then, and we did not move forward. But it happened that a couple of years back, we put 2 lacunary provisions in the Criminal Procedure Code, Article 25 and Article 26 of the Criminal Procedure Code. In my humble view, we need a comprehensive legislation about ADR in criminal matters. We need a specific criminal procedure law in ADR matters. So we cannot continue, in my humble view, relying on guidelines from the Honorable Chief Justice and the Prosecutor General. As I don't know whether Justice Andrew mentioned it. Sometimes it is questioned whether we should venture into criminal matters by relying on guidelines. So we should really empower this system by bringing all these details which are within the guidelines through a legislation. And therefore the legislation will be developed through case laws. And I think that's how we can, that will be the process of building a strong and sustainable regime behind all these process. So that's one. Second, I think the academia should understand that we are not going to come back to the process of litigation. But as we are sitting here speaking about ADR, speaking about promoting peace, justice that is promoting peace, within the universities that are teaching litigation. So we are having a problem of a student coming to the institute. When we speak ADR, it is the first time they are hearing it. So all the subjects within the universities should be leading towards resolving a dispute by relying on ADR. For instance, in many commercial aspects, if you go to investment, you go to intellectual property, you go to commercial transactions, there is always, even in these international treaties, there is always an ADR component of a dispute resolution within these treaties. But our students are studying litigation. So when they come out, when they go in yes, I remember yesterday we had a call with World Intellectual Property Organization following the course that LPD is doing with WIPO. And they were telling us that we should start thinking about how to introduce ADR into intellectual property. So the ADR is, in fact, the way to go. So we can study the principles of a contract, but when the principles of a contract are colliding, we should resort to ADR. So we should, when we are supporting a creative industry and protecting a copyright and whatever, we should remember that if there is a conflict of a copyright, the solution should be ADR. So ADR is, in fact, the justice which is resolving problems. And the problem, maybe let me conclude by there. My observation about this is that Africans were so behind as regards enforcing ADR, whereas as Mr. Badrock is mentioning, it is our own culture. But these ADR mechanisms, they have now been taken from us, and they have been the basis, for example, of an International Mediation Institute. There is a Singapore International Mediation Institute. There is everywhere in the world. They have taken our values. They have created institutions around them. And for us, we have remained 1 century back in litigation. And we are so happy about litigation. We're promoting litigation. So I think we should work up and build our justice system based on the ingredients that are connecting the justice institutions to the population.
Thank you so much. You can see his anger. Elvis, do you have the same anger? This time wearing your other hat as from IPIS. And do you plan to influence even other civil society organizations to join you as you support ADR mechanisms?
Yes, if it's anger, then it is holy anger, as they say in the Bible. So I wouldn't say that it is anger, but I believe that when you climb a mountain, you only discover that there are many more mountains to be climbed. And that requires extra effort. As I said in the morning, this requires dialogue, this requires partnerships, this requires frequent questioning, because that is very fundamental. Whatever we can do, whatever we can try, we need to stop at a certain point and assess where have we been, where have we been intending to go, and where are we standing. And in that trip, we have public institutions, we have civil society organizations, we have the academia. So it's something that we have to work together. And there's also something that was said here about awareness. The justice is delivered in the name of the people. How do we ensure that people who are in Mugomga, very far, in remote rural areas, are informed about this change of paradigm that we are living? So that is something that civil society organization we have to do, and IPIS we have tried to do, and we are still playing our parts. We are joined with Alert and other organizations. I believe that when we keep the forum open, when we talk about this, it is broadcast, we talk about this more and more, then people will feel, as Rector has just said, ADR is the way, and effort will be joined to go that way. Thank you.
Thank you so much. I don't have more questions. I would request the audience to join me, clap for this panel. Thank you so much. And then I hand over to Justice Mutabazi. If we have 1 or 2 questions, I'm not sure. My work was to moderate. If it comes to questions, we'll need your guidance.
All right, thank you very much. Please, another big round of applause to the to the panelists. They've really done very well. They've done justice to what they were supposed to speak about. I don't know if there's a question. Looking from the face of the audience, and well, there's none, definitely. So it means it has sunk in very well. You did tremendously, very well. So, and there wasn't anything that was to be asked or put on together on what you said. So please give them a round of applause as they resume their seats, and please you can go back to your seats. We're transitioning to the end of our our symposium, and as we usually say, talking about ADR and mainly plea bargaining and victim offender mediation, as we usually say, we can speak and till the cows come home, and it's almost they were coming home, the chickens come home, so definitely. So please indulge us, and thank you very much, audience. You've been a very good audience. You've indulged with us, you've stayed in put. I couldn't believe that you could stay around this time still seated. It means what we're saying made a lot of sense. So give yourselves also a big round of applause, isn't it? Thank you very much for this. And definitely we hope we'll have more of these symposiums in the future with IPs, alert, and the rest of the development matters that are here in that way. So as I said at this juncture, we're going to have the closing remarks from the Honorable Justice, Lady Justice Chanzaire. Please, it's your time to come. And then after, we'll have the group photo in that line. Thank you so very much. And as he comes, please, the guests of honor, applaud her. Please, yourself.
Representatives of justice sector institutions, development partners, members of academia and civil society, our keynote speaker, ladies and gentlemen, mwiriwe neza. It is my great honor and privilege to join you today at this high-level symposium on alternative dispute resolution under the timely and important theme, plea bargaining and victim offender mediation, building capacity for efficient, restorative, and people-centered criminal justice system in Rwanda. Allow me at the beginning to sincerely thank the Institute of Legal Practice and Development and the Initiatives for Peace and Human Rights for partnering with the Judiciary of Rwanda in organizing this important symposium. I also extend my appreciation to our development partners, all participants, and distinguished speakers who have taken time to contribute to this critical national dialogue. Ladies and gentlemen, across the world, justice systems are increasingly recognizing that effective justice is not measured solely by punishment, but also by the ability to restore relationships, promote accountability, heal communities, and preserve human dignity. It is in this context that alternative dispute resolution mechanisms have become indispensable pillars of modern justice systems. In Rwanda, the pursuit of justice has always been closely linked to reconciliation, unity, and social cohesion. And our history has taught us that sustainable peace cannot be achieved through retribution alone. It requires dialogue, truth, rehabilitation, and restoration. With the adoption of ADR policy and criminal justice policy in 2022, the government of Rwanda demonstrated a strong commitment to advancing restorative justice mechanisms, including pre-bargaining and victim offender mediation. These reforms represent an important shift toward a more human, participatory, and people-centered criminal justice system. I am pleased to note that the progress achieved so far is both significant and encouraging. The increasing number of criminal cases resolved through pre-bargaining and victim offender mediation reflects growing institutional confidence in restorative approaches and the willingness of stakeholders to embrace more efficient mechanisms of dispute resolution. In just 8 months, 1,458 cases were successfully resolved through victim offender mediation, while 34,550 cases were resolved through pre-bargaining over a period of 41 months. These achievements demonstrate the practical impact and growing acceptance of ADR mechanisms within the criminal justice system. Beyond reducing case backlog and easing pressure on detention facilities, these mechanisms contribute meaningfully to reconciliation, accountability, social harmony, and the reintegration of offender into the society. However, while we celebrate these achievements, we must also acknowledge that important challenges remain. The effective implementation of pre-bargaining and victim offender mediation requires strong institutional coordination, consistent practices across justice sectors, institutions, continuous professional training, and greater public awareness. Restorative justice mechanisms demand not only legal reforms, but also a transformation in mindset and professional culture. The symposium is therefore both timely and highly relevant. It offers an important platform for reflection, open and constructive dialogue, exchange of experiences, and identification of practical and sustainable solutions. I particularly commend the sectoral composition of this gathering, which brings together representatives from the judiciary, the prosecution, the Rwanda Investigation Bureau, academia, civil society, and development partners. Indeed, strengthening restorative justice is a collective responsibility that can only be achieved through sustained collaboration across institutions and disciplines. Ladies and gentlemen, as justice leaders and practitioners, we must continue asking ourselves the following questions. How do we ensure that restorative justice mechanisms remain fair, transparent, and victim-centered? How do we build sufficient restorative technical capacity among prosecutors, judges, investigators, mediators, and legal practitioners? And how do we ensure harmonized implementation across institutions? how do we strengthen public trust and awareness so that citizens fully understand the value of these mechanisms? The orientation given to these questions will lead continual discussions and determine the sustainability and effectiveness of our reforms. The judiciary of Rwanda remains fully committed to supporting initiatives that improve access to justice, enhance judicial efficiency, accountability, promote reconciliation, and uphold the dignity of every individual within the justice system. As we move forward, we must continue building a criminal justice system that is not only effective in enforcing the law, but also compassionate, restorative, and responsive to the needs of the society. Allow me, before I conclude, to extend my gratitude to our distinguished keynote speaker, Professor Justice Andrew Kawoka. I hope I pronounce well. Our panelists and our participants for dedicating your time, expertise, and valuable contributions to this important dialogue. Your commitment and active engagement have greatly reaffirmed our shared dedication to strengthening restorative justice in Rwanda. I liked what Justice Jean-Pierre and Rwagasana said. Prison si izacu, gufunga si ibyacu. Guca urubanza ni uguca ikirutera. Iyo urubanza rw'Abanyarwanda rurangiye ntirutera impaka n'inzigo. Ni amagambo numvise akomeye atureba cyane cyane twebwe dukora uyu mwuga w'ubucamanza, kuko tujya twicara tukareba amategeko tugaca urubanza tukumva birangiriye aho, ariko ntitureba inyuma ikigiye gukurikiraho. Dufashije Abanyarwanda babandi bari bafitanye impaka kongera kwicara bakaganira bakabana neza. Niho numva rero ingufu z'ubu buryo bushya bwo gukemura amakimbirane bidaciye mu manza, tukaba dukwiye kongera guha agaciro uyu muco wacu. Dufatanye rero twese dushyire imbaraga mu bukangurambaga, dushyireho ingamba zituma ubwo bukangurambaga bushoboka n'ibindi bizashoboka. Nkiri mu rwego rw'umuvunyi twigeze kujya gukemura ibibazo by'abaturage, ariko tufitemo na gahunda y'ubukangurambaga kwigisha abantu kutihutira kujya mu manza. Umuturage umwe araza atanga ubuhamya, avuga ukuntu yahoze ari umucuruzi, afite amaduka, afite imodoka, hanyuma akajya mu manza, imanza zikarangira za modoka zose zaragiye, nta nza kigira, nta faranga kigira. Ubwo buhamya bwatumye abantu bumva ibyo twashakaga kubabwira kurenza amagambo twebwe twababwiraga. Niyo mpamvu numva n'ubukangurambaga tujyamo ubu ngubu ku bijyanye n'ubu buryo bushya bwo gukemura amakimbirane dushobora kwifashisha abantu babinyuzemo bakavanamo inyungu, nibo bashobora gusobanurira abandi bakabyitabira kurenza amagambo yose twakoresha. Naje rero ndi intumwa, nagira ngo mu izina ry'uwantumye mvuge ko urwego rw'ubucamanza ruri committed gufatanya n'izindi nzego mu gushyira mu bikorwa imyanzuro y'iyi nama kugira ngo uburyo bwo gukemura amakimbirane bitanyuze mu nkiko bizakomeze kugira imbaraga. Thank you once again for your presence and meaningful contributions, and may God bless you.
I want to thank Lady Justice Lanzecha Nzairi for the remarks and the concluding remarks that were so profound and really cemented the entire symposium in that way. And we've come to the conclusion of the symposium, and as I said, we'll have one item that we'll conclude with, that is a group photo, and then we'll be proceeding off for lunch and then end in that way. We'd like to let you know also that we had a very big audience that was following us on live stream. We had on YouTube, so if you have a moment, you can review our symposium on YouTube. And we'd like to thank the online community that stayed with us till thus far. Thank you so very much. So once again, ladies and gentlemen, it was a pleasure being your host, and thank you so very much. Till next time. So, and then we will have the middle table, have the seats, and then